Okay, we're going to start the call the meeting of the Town Plan and Zoning Commission on March 14th to order. First order of business, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We'll have the secretary read the roll. Here.
Here.
Here. Commissioner Fox.
Here.
Commissioner Payne.
Here.
Commissioner Sobieski.
Here.
Commissioner Woods.
Here.
Commissioner Vitalica. Commissioner Braverman.
Here.
Commissioner Giangrave.
Okay, we have all the commission members are here for the public hearing. We have Commissioner Claffey has had a prior engagement, but he is on the speakerphone. He's be listening to the proceedings. This is a precedent set by the town council in the past. We have a legal opinion that it is a legal, meets the legality of having him here as a quorum and as a voting member. So we'll proceed. Approval of the agenda. I'll call on the town planner.
Yes, Mr. Chairman, I have two items that I recommend you remove and two items to add. I recommend you remove new business item A, petition 01-18, site plan approval at 3443 Berlin Turnpike. This is that retail site building on the Berlin Turnpike where the applicants would like to be able to pave a portion of the front yard, which the regulations don't allow along the Berlin Turnpike. They're going to the Zoning Board of Appeals for a variance, and if they're successful, then they'll come back and proceed with the plan as submitted. So they've asked that be tabled until your first meeting in April. So I recommend that be removed for tonight. The second item to be removed under new business, petition 07-18, site plan approval at 2226 Mazzicoli Way. This is the site plan approval for the parking lot, the library parking lot. We put it on the agenda because we thought the architects would have the plan ready for the commission's approval, but the staff kind of got ahead of the architects, so it's not ready for the commission's attention yet. So please remove that. And two new items came in just yesterday, and that doesn't meet the normal deadline to get on the agenda, but time was something of the essence, and both of these items are simply for scheduling a public hearing, so I recommend you add them. The first item is petition 08-18, zoning text amendment, section 6.16.3 for medical marijuana. This would be an amendment to the existing medical marijuana regulations, which currently only allow a medical marijuana distributor facility in the industrial zone. This text amendment, if approved, would allow medical marijuana to be distributed also at a location in the Berlin Turnpike business zone, the BBT zone. Now, because it is a townwide text amendment, it needs to be sent to CROG at least 30 days before the hearing. So the earliest the hearing for that would be the, I'm sorry, I have notes myself here, would be April 25. So I recommend the hearing be scheduled for April 25. Now, if they're successful in getting the text amendment, they will then want to apply for a special permit. And so they've also applied for a special permit, and I recommend that hearing also be scheduled for April 25th.
Okay, those will come under our section of the agenda. Correct. Under scheduling, and we'll discuss it further there.
And that's all, Mr. Chairman.
Okay. Any questions or on the changes to the agenda? Any comments? Hearing none, can I have a motion?
So moved. Second.
Motion made and second. All in favor?
Aye.
Opposed?
Aye.
Who was opposed? Oh, okay. Sorry. Okay. Then moving along, we have the zoning enforcement officers. Public participation on items not listed on the agenda. Anyone from the public wishing to speak on an item that is not on the agenda, please come forward, state your name and address for the record. Anyone? Seeing none, you're at the public hearing. You have an opportunity to talk on the applications that you're here to witness. Next item on the agenda is zoning enforcement officer's report. Turn that over to Mike.
Okay, so I do have a number of temporary sign applications that I want to go over with you, but I guess first we should start with the actual report itself. I will note that there are a number of properties on here that have applied for temporary signs that you're about to see. So we will update this, assuming they receive approval. If anybody has any questions, certainly address them or try to.
Mike, if you could run through all of them at once. If the commissioners have any particular comments or questions on any one of them, we'll try to move it along. These are items that the commission has asked you to contact the owners. Most of these people are in compliance. It's just that they never came for a permit.
So the first one is 3145 Berlin Turnpike. That's Mortenson's Ice Cream. We've got an application here for a temporary sign, and got a couple of different things to show you. First, here's a photo of the proposed sign in the proposed location. It meets the size criteria, and the site plan is here, which shows where the sign is being proposed. The sign that actually has been here for a number of years. He'd like to bring it into compliance. So that is the first one.
Any questions on this application? Go ahead, Mike.
The second one is 3127 Connecticut Beverage Mart. Here is the application, and there is a photo of the sign as well. He's proposing to put the sign right here in this hashed area. There's nothing on the sign now because it does change depending on what he's doing, but it will be basically right outside the sidewalk there in that non-parking spot. He has problems with people trying to park here, so it sort of doubles as an area to keep this open for pedestrians.
That's within the 5 feet to the door?
Yeah, it's hard for me to show on here because of the scale to get the whole site, but the permits, when they print out, state that it's got to be within that distance.
Any questions on this application, commissioners?
No.
Excuse me.
Yes.
Is that within the walkway? Is that going to impede the walkway of people going back and forth? It looks like it's a
It
hazard.
should be just off the sidewalk in the parking lot, so the sidewalk up along parallel with the building, it won't be there. So anybody who gets out of the car and walks shouldn't be a
That was my
problem.
only question. Thank you.
Okay. Next one is 3475 Stu Leonard's. They were in December for a 25-day permit for their Christmas trees. They would like to also put, let me see if I can flip this. They want to put up a sign for 25 days to show the garden shop. It's the same size banner. It will be in the same location for 25 days. They would like to start April 14th and leave it up until May 8th.
You're all familiar with this location and the sign that we approved in the past during the Christmas holiday. They had the Christmas tree sale, I believe, sign. So it's the same size sign and it meets the regulations. Any questions? Okay.
All right. Going. Next one. 107 Fenn Road. Here's the photo of the sign in the actual location. This is a multi-tenant building with individual entrances on the west side of Fenn Road. Here is an aerial photo showing that they basically put it right next to the door. Here's the entrance for their particular unit. And it helps them when they have their folks coming in to do their test prep to distinguish which unit they're in. Anybody have any questions on that one?
What's that?
Okay. Next one, 548 Cedar Street. I'm going to show you the rendering. This is the one side of the sign. This is the second side of the sign. They are permitting all the locations in Newington with the same sign. So rather than go through and show you the same one for each, this is the same sign they're going to permit in each location. And I have the site plan here. So this is the one on Cedar Street. This is a sidewalk and then a landscape area, and the door is right about here. They want to have the sign out at that spot. I can move on to the next location, which is 2601 Berlin Turnpike. This is the door entrance here, so this is roughly a 5-foot radius. Obviously, it shows on the sidewalk now, but they understand that it can't obstruct anybody's access to the building, especially with the handicap spot there. 2368 Berlin Turnpike, again, is another one. These are all managed by the same person, which is why they all came in together. Aerial sign, there's the entrance there. This is next to Wendy's near the old drive-in, just for a frame of reference. 1097 Main Street. So I just have a note here. The way that they locate it now, which is how we found out about it, is actually under the canopy, about in here, but obviously I can't show you that. So I'm showing that that's where that is there. The door is just north of that. And the last one on Kelsey Street, 194, also shows the area in here, and there is a portion which is accessible from underneath the canopy as well, but just for the purpose of showing the portion of the property. So again, all those Dunkin' Donuts signs are going to be exactly the same on both sides. Does anybody have any questions?
Any questions from the commissioners? The only thing I would make sure that some of these signs are out now, and some of them are in the right-of-way, in the street right-of-way.
Okay.
So they got to be, this particular owner, you have to make sure that they understand that the locations are what they're showing us on this site plan.
And the approval dates, if you approve them tonight, basically would be till June 15th, and they'd have to come back.
Mr. Sobieski?
No, we'll approve this. I have another question, another sign.
Is that it, Mike?
Yep, that's all of them. There's 9 in total.
Okay, you got a question?
Yes, in the center of town, on Starbucks, on the west side, there's a big bed sheet hung up that says store for rent. It's been up there for quite a while now. Several people have called me, I know they've called the town, and asked about it. It's Rich Hayes' property. Now, if we're going to be strict about these signs, I think we should be strict about that.
You take a look at it.
Yep.
Anything else? Mr. Payne?
Mr. Chairman, if nobody has any other questions, can I make a motion to approve these, was it 9 or 10?
9.
9 temporary signs?
Make a second.
Motion made and second. Any questions, comments? Seeing none, all in favor?
Aye.
Opposed? Stanley, your mic has got like a delay.
No, it's Mr. Claffey.
Oh, that's Mr. Claffey.
It's not me.
Wonder where it's coming from.
So before you say opposed, just
Okay. All right. Any other items for the zoning enforcement officer? Mike, you have anything else?
That's all I have.
Okay. Next item, remarks by commissioners. Any comments at this time? Seeing none, the next item is public hearings. We'll have the secretary read the rules that we follow, our procedures which we follow for public hearings, and we'll go right into the hearings tonight. Go ahead.
The order of proceedings at a public hearing shall be as follows. A, convening by a chairman. B, reading of the notice by the commission secretary or a commissioner designated by the chairman to act in his stead. C, identification and location of the property involved by the town planner. D, a statement of the issue to be considered by the chairman or the town planner. E, presentation by the applicant limited to 20 minutes unless a specific extension is granted by the chair. F, persons wishing to speak in favor of the application limited to 2 minutes per person. G, persons wishing to speak in opposition to the application limited to 3 minutes per person. H, rebuttal by the applicant limited to 5 minutes total. I, rebuttal by the opposition limited to 5 minutes total. During a public hearing, it shall be within the discretion of the chairman whether the time limit should be varied slightly, provided the commission consents to any such variance. In no case shall an extension be for more than 20% of the allotment indicated above, or 1 minute, whichever is greater.
Okay, well, is the applicant here? Come forward, please, make a presentation. Picking it up, Lori?
Yes.
You can be able to understand it?
It's not very good.
We've got this one running as well as a backup.
It's tape?
It's a digital.
Okay.
Yeah, we're going to try to speak more into the mic so that we get picked up and the people at home and the people in the audience can hear what we're saying. And we've got to make sure that we have a complete record. Go ahead, I'm sorry. Proceed.
Well, let's test this and see whether, are you getting something on this? Okay. Good evening, members of the commission, members of the public. My name is Robin Pearson. I'm an attorney with the law firm of Alter and Pearson in Glastonbury, Connecticut, and I'm here this evening on behalf of the applicant, Amy Berube, who is pursuing a text amendment to your regulations to allow doggy daycare in her home. Before proceeding, I have an issue that I think it's important to raise with regard to tonight's proceeding, actually two proceedings, both the text amendment and the open home occupation special permit application that is still pending before this commission. I don't do this lightly, but I am very concerned now, more so than originally was expressed to you at the beginning of the related home occupation special permit application, that my client may not be able to get a fair hearing from this body because of personal interest and just general predetermination of the issues that are involved. So I think it's imperative that I put this on the record. Case law says, in fact, that if I don't put it on the record, it's not something that I can raise later. Again, I don't do it lightly, but I'm going to proceed tonight to do that. I'm going to request specifically that Commissioner Payne recuse himself from this proceeding on the zone change or text amendment. It's his decision to make. He has to be the one that decides whether or not he can continue to consider this application or the special permit home occupation application that's currently pending. But let me tell you why I get here. This proposal to amend the zoning text to allow doggy daycare, if you will, in a residential zone is inextricably related to the home occupation application that is currently pending before you. We are here with this zone change request, or this text amendment, basically at the urging of the commission as a possibly more acceptable route to facilitating Ms. Berube's ability to continue her dog care use of her home, as opposed to trying to secure an approval under the home occupation provisions of your regulations. We have been told that at least one neighbor complained about concerns with regard to the use of her property for the at-home daycare for dogs. And it was this commission's own investigation that confirmed that no noise complaints had ever been filed with either the animal control officer or the police department with regard to her home occupation, which, as you know, had been proceeding based on that testimony in those proceedings for over 6 years before we got to the point where she was asked to come in and get a permit. And I don't disagree that if you're running a business in a home, then you should pursue a permit under the home occupation. We already noted that. But notwithstanding the support of all of her neighbors, except for one, who I note did appear before you during all those nights of proceedings, she had an incredible amount of support from persons who are interested in being able to see her continue that business as a home occupation. I note that the opposition that was expressed at those proceedings by that one person really was more general than specific in nature. As I recall, it indicated that there were dogs in the neighborhood that barked and irritated her, but I don't think she specifically said that they were the clients, they were client dogs. And I also know that she never, or at least there was no record of her filing a noise complaint. So given all that, we did wonder, well then how did, notwithstanding the fact that if one's conducting a home occupation, you should get a permit, but how did this come to light, and where was the complaint coming from, and what were the issues that drove somebody to file a complaint with the town? So late last month, we filed a FOIA request with the town to figure out exactly where the concerns came from. And as it turns out, based on the records that we received as a result of the FOIA request and the records we addressed to the zoning enforcement officer, and I know this could make him uncomfortable, but we felt we really had to understand what was behind the concern for this type of use. And the complaint actually came in from Nicole Payne, who is, as you probably know, is the daughter of Commissioner Payne. And the complaint, I'm sorry, I'll leave you with a copy of it. But the complaint, per the materials that we secured from the zoning enforcement officer, was filed on July 28, 2017, and it was an email addressed to the zoning enforcement officer, and it said, "Hey Mike, it came from Nicole Payne. I had a person speak to me on a delivery in Newington around the golf course and told me about a business being run in the home. The person told me it was a canine camp with boarding. I did come back and did look it up, and it's called Shelby's House, a canine camp. It's located on 172 Indian Hill Road. I'm wondering if this is allowed in the town and if there are regulations on how many animals she could have at once and could become a nuisance." And I know, could become a nuisance with barking. "If you could let me know the regs, I'd appreciate it, and if it is an issue, it should be dealt with. Thanks, Nicole." Subsequent to that, he did proceed to speak with the animal control officer. His follow-up notations in the file indicate that, and that is based, and then he contacted Ms. Berube, and that's what brought us to where we are today. So it was not a result of any particular noise complaint about this property. It was something that was observed and was brought to the attention of the CEO. My concern is that it didn't originate from the neighborhood itself. It came from somebody, actually the only person who filed the complaint was Ms. Payne, but apparently she got the information, or the concern was raised from somebody from the golf course area. And we do acknowledge that complaints can be made by any member of the public, and that's certainly appropriate. What concerns us here, and Amy, is that we are afraid her application will not be fairly judged from a legal standpoint because of the connection between the complainant and a member of the commission. And it's not just that one connection. We have observed through the proceedings that certainly the chairman, but also Mr. Payne, have been particularly adamant about the inappropriateness of the home occupation use, and that what was being proposed did not fit within a home occupation, that it was a commercial kennel and therefore was not allowed in a residential zone. From a legal standpoint, remember that at the very beginning when we started with the home occupation application, we referred you to your minutes, and we noted that a number of commissioners, but primarily the chairman and also Mr. Payne, had made comments that gave us pause. And to our mind, those comments raised the possibility that Amy's application was basically dead on arrival, because at least 2 members seemed predisposed not to think there was any possibility it would be approved. Certainly, if that's true, it would constitute illegal prejudgment and deprive her of a fair hearing. We suggested to Amy at that time that she not ask anyone to recuse themselves. We didn't know at that time that it came through Mr. Payne's relative with regard to the complaint itself.
I have to stop you right there. Are you aware that Ms. Payne is the chairman of the zoning board of appeals? And
Yes.
in her capacity as the chairman of the zoning board of appeals, that she got a complaint from a citizen, and it's her responsibility to report that complaint to her employee, which was Mr. D'Amato, the zoning enforcement officer. If you're going to tell us a story, tell us the whole story.
We are
Okay.
aware that she is a member of the Zoning Board of Appeals.
Why didn't you state that when you said that, Ms. Payne, just off the top of your head? You have a way of only telling your side of the story. You leave out some important facts, and you've done that right along through your whole testimony. So go ahead, proceed.
Mr.
Just
Chairman.
make sure that the record is clear that she is the chairman of the Zoning Board of Appeals, and she had a responsibility from a complaint from a citizen to report it to her, to the town official, the town staff.
Mr. Chairman.
Just make sure that that's part of the record.
Mr. Chairman, you have made it part of the record, and I
You didn't
note for
put that
you,
as part of the record, not putting that part of the record.
and I note for you that there's nothing in the complaint that was filed that indicates by her that it was a function of her position as being on the Zoning Board of Appeals. And I also
She didn't
note,
have to tell the zoning enforcement officer that she is the chairman of the Zoning Board of Appeals. He is the staff member for that commission. Stop splitting hairs here and continue with your thing and proceed with your application.
Mr. Chairman,
You're eating into your time.
Mr. Chairman, I have to take exception with the tone that you are conveying your concerns to me. These are valid concerns that we have, and we have to put them on the record, and I am doing that. To be perfectly legal with regard to the Zoning Board of Appeals, there's nothing in the statutory jurisdiction of the Zoning Board of Appeals that says their responsibility is to either peruse the town to check on zoning enforcement issues, or as a function of being on the Zoning Board of Appeals, convey those issues of possible non-enforcement to the zoning enforcement officer. That's something that is not within the jurisdictional mandate for the Zoning Board of Appeals by state statute. So I put that simply on the record. All I'm looking for is for a fair hearing on all of these matters. And also, frankly, that is something that should be of concern to the commission, because it's imperative for you to make sure that there is no perception that there's been any improper or unnecessary influence, or someone is not able to get a complete, open, and fair hearing. So, and I take exception that I have not been truthful in providing you with information with regard to either this application that we have not gotten into, or the next one, or the one that's currently pending for the home occupation. So what I was going to say is we suggested to Amy that she not ask anyone specifically to recuse themselves for that home occupation. As you'll recall, we recited some sections from the zoning minutes of the proceeding when her application for the home occupation was first accepted or discussed before actually being accepted and taken up as a matter for business. And we said if any of you, based on our concerns for those comments, felt that they could not be fair, then they should recuse themselves. We were not specific. We did not know at that time that it had come through Ms. Payne. So, you know, that was before we learned, as we have now, that it was Ms. Payne that started this all in motion and that she is the chairperson's daughter. And frankly, Mr. Payne could have acknowledged that. There was a lot of discussion during the course of that proceeding as to where this concern came from. And I do recall some discussion about, well, it was anonymous and should remain anonymous. We now know where it came from, so now we are concerned enough to put that on the record, and that's what we are doing. So with that said, I will not spend a lot more time going through the law, but I will just direct you to the Trafaletti case, which says there have to be rules in place to protect the integrity of the process. A personal interest, we have said, is a personal bias or prejudice which imperils the open-mindedness and sense of fairness which a zoning official in our state is required to possess. We are concerned that that may be the case here. And if it's only the appearance of that, then that's enough to suggest, to make sure that there are no issues with regard to the proceeding, that a member who does not feel they can decide it fairly without prejudice recuse themselves. A personal interest is an interest that takes the form of favoritism towards one party or hostility towards another party. It affects the open-mindedness and sense of fairness which a zoning official in our state is required to possess, and that comes from the Anderson versus Zoning Commission of Norwalk. And I would just like to add one other thing, which is that when you read Judge Fuller's treatise that deals with the conduct of these types of hearings, predetermination exists where the agency members were irrevocably committed to the particular action no matter what evidence was produced. It occurs where the agency members actually made up their minds prior to the hearing. So again, this is not done lightly, but we feel it's important at this point. We think it's necessary and ask that Mr. Payne recuse himself from the proceedings of this and for the home occupation. And I will ask that that happens before the hearing on that matter is closed, which I understand will happen tonight. So I put it out there. If Mr. Payne has no comment or...
Yeah, I take my job as sitting on this board seriously, and I don't feel I've prejudged anything. We haven't deliberated on anything. And as far as the complaint that came in, the complaint didn't come from my daughter. It was given to my daughter, and she gave that information to the town. So I will not recuse myself on either matter.
Okay, so now we move to the text of the application that's before you tonight. And we have submitted, at your urging, because there was a fair amount of testimony in the record that it was thought that the home occupation did not accommodate Ms. Berube use, and it was suggested that we proceed to file a text amendment that would provide an opportunity through the special permit process to allow individuals who wish to conduct a in-home dog care business in a residential zone to be able to proceed with an application to this body through a special permit application. The text of the application is on the screen behind you. It defines in-home dog care as a business in which the operator cares for other person's dogs at the operator's residence, including overnight stays, provided the maximum number of dogs shall not exceed 5 at any one time, which number shall not include the operator's personal dogs. We based this on a need, which we identified as having been made clear to you during the home occupation process, where extensive testimony was offered before you on December 14th, January 10, and January 24th as to the need for in-home dog care for the community. During that process, we said to you that we felt the use could easily be accommodated within the home occupation provisions that currently exist. You subsequently suggested that we pursue the text change as a perhaps better mode of dealing with this, which we are now doing. We took the parameters that Ms. Berube used in making sure she was running a very professional, quiet, non-intensive dog care business in her home, and used those as a guideline to set out what types of requirements would be appropriate if one were to adopt a regulation as we have proposed to ensure that there is no negative impact on the neighborhood in which someone might pursue one of these dog care home businesses. And those standards are set out under our proposed 3.4.10. Again, above you, they say the location shall be the permanent resident of the person or persons conducting the in-home dog care business. A fence shall encompass the entire rear and or side yard of the residence as appropriate, so that no evidence of in-home dog care business shall be visible outside the residence from the street or neighboring properties, except at the point of drop-off and pickup. The operator shall keep the following information at his or her residence at all times during the permit period. A, proof that all client dogs have up-to-date vaccinations provided by a licensed veterinarian. B, certifications from client dog owners that the client dog is in good health and has not been ill with a communicable condition in the last 30 days, said certifications to be updated quarterly. And C, proof that all client dogs over the age of 1 have been spayed or neutered. D, all client dogs must be dropped off and picked up at the residence on a collar and leash. E, only one client dog may be dropped off and picked up at any time. And this is certainly different than what you would have with a commercial kennel-type operation attendant to a veterinarian facility. Highly regulated proposed limitation here. It is intended to control the intensity of the use. Drop-offs and pickups must be done at a mutually agreed-upon time between the operator and the client dog owner. G, no excessive barking shall be permitted outside the residence, and the operator shall expeditiously remove such barking dog to the operator's dwelling. H, the operator shall secure a pet facility license from the State of Connecticut Department of Agriculture or other required license as may be determined by said department to be applicable to an in-home dog care business subsequent to zoning approval. Now, again, as I mentioned before, all of these could just as easily be conditions on the home occupation permit should you instead propose to limit this specifically to Amy Berube, which you could do through the home occupation. Your own home occupation regulations at 3.4.4 say home occupation permits are non-transferable, so they would stay with Amy, be specific only to Amy. This, of course, opens it up to the possibility more people would pursue a special permit. Whether more would or not, I guess that's not fair, because they could still pursue it through the home occupation or pursue it this way through the special permit. Both require a special permit through the zoning reg as a separate section. Your home occupation has a regulation, has a section that says that home occupations can be revoked, or the permit can be revoked for good cause, and that's under 3.4.4 also of your regulation. So there are a lot of reasons, I think, why the home occupation may be a better way to go, but again, you suggested that we pursue this, so we are doing so. Another concern we did have was that the notice for this particular application seems to have been significantly different than the notices that would be required for a typical text amendment. As Mr. Minor, your planner, noted in the proceedings when this was received and set for public hearing, the town typically does nothing more than to post a notice as it does for any zone change or text amendment in the paper. It was the suggestion, and I believe it was the chair and Mr. Payne, that this receives special notice, different from any other use that you have, or text amendment that you've previously considered. And you did post at the expense of $500, half a full page, a half of an ad in the, I forget the name of the paper. Rare Reminder. So again, I think this has been targeted for special treatment. I don't disagree that more notice can be helpful, but it is different. It is definitely something that's different from the other text amendments. And you have approved 2 recently that affect uses in residential zones. We went through your text amendment section of the regulations, and there was one that was approved in 2015 that didn't require this special notice, that allowed for contractor vehicles and other commercial vehicles to be parked in residential zones. And there was another one for rear yards in residential zones, which arguably might create a more intensive type use, be of particular interest to residential property owners. But unlike this particular application, you didn't put forth an unusually significant notice to publicize the pending application. So hopefully the notice has resulted in an opportunity for everybody to have a chance to consider this and be here this evening and talk about this particular application. We think if it...
You're going to have to wrap up. You're beyond your 20-minute time period.
Okay.
I've given you an extra 20% allotment for additional time. Our rules require that you, at this point, wrap up your presentation.
All right, I think we've pretty much gone through everything we need to say about it. We think it makes sense. I'd like to point you to that section of your Plan of Conservation and Development, which is under the Strategies section on page 38. It's item 22, and it basically is a strong paragraph that promotes home occupation type, well, it's called home-based businesses. It's not specific to home occupation businesses. It's specific, however, to suggesting that your own Plan of Conservation and Development states to the Commission that you should reach out and support businesses that can be conducted within the home. I'm going to read it to you. It's a short paragraph. Recognize that home business...
Thank you. You ran out of your time.
No, Mr. Chairman, I, as the applicant, have the right to submit everything I want to submit.
We have rules and procedures. I've allowed you to go way beyond your 20 minutes, plus I've given you an extra 20% per our rules and procedure. You got to wrap it up.
I will wrap it up. I have a 7-line paragraph I'm going to read, but the applicant has the right to present everything the applicant deems is relative and important for the Commission to consider with regard to an application. Certainly what your Plan of Conservation and Development says about home-based businesses is important. So I'll read it. Recognize that home business occupations increase employment opportunities for Newington residents, but their impact on the adjacent neighborhood should not cause a nuisance. Business uses of residential property should not permit retail sales, storage of commercial equipment, personal services, or consulting with clients within the home. Evaluation of home businesses by special exception standards and conditions will be implemented to protect residential properties. This application fits that directive perfectly. So with that, we conclude. Is there anything I've missed, Meg? We hope you will approve this application, and we thank you for the time that you've given us.
Any questions from the commissioners to the applicant? Seeing none, we'll go into the public portion of the meeting. We'll ask that people wishing to speak in favor of this application limited to 2 minutes per person. Come forward, state your name and address, your complete name, your complete address, and if possible, if you are a client of Ms. Berube, it's for the record. So, anyone wish to come forward at this point? You're limited to 2 minutes. We're going to hold to the time periods because of the number of people here.
Hi, I'm Dawn Kitco, and this is my husband, Mike, and we live at 4 Terry Road in Gales Ferry. I'm nervous, which is like an hour away, and we've used Amy on several occasions because we've got rescue dogs, and our oldest dog gets stressed. She didn't have a very good start in life, and it would kill her to put her in a kennel, would it not? And so, for that reason, we don't go on vacation, but my family are in England, and sometimes they need us and we have to go. And without Amy, our dog would be dead. So, and that's it. Thank you.
Anyone else, please?
Good evening. My name is this one. My name is Lisa Vassi, 12 Pfister Drive. I am a client of Amy's. In the early summer of 2011, we became the first and proud owners of a 4-month-old Shih Tzu. This was the first dog me or my husband or my family have ever owned. Having already booked a vacation for that summer and not knowing any better, I did book a reservation for him at a traditional kennel that marketed itself as a pet resort, hotel, and spa. However, once you got past the lobby, it was anything but spa-like. It was very cold. The industrial feel of the place felt very institutional. They had individual cages, or runs as they call them, cement floors, cots, and metal fencing which separated the dogs from each other. Any type of playtime or walks that you wanted for your dog was on an a la carte basis and can become very costly. The dogs that were being boarded were not allowed to play with the other dogs for fear that they might not get along. In a nutshell, I'm sure that our dog received adequate care, but I just did not leave there with a great feeling. I met Amy in 2014 and found out that she ran a doggy daycare. With another summer vacation approaching, we asked her if we could board our dog with her. First, she scheduled a meet and greet. This is when your dog actually goes, checks out the environment. Amy has 2 dogs of her own as well as 2 small children, so it's very important to her that everybody gets along. A contract is drawn up. She gave us specific information. We needed to provide vaccination history. Everything was very organized. When I dropped my dog off before our vacation, I literally felt like I was dropping him off at Grandma's house. Over the course of our vacation, we got daily pictures, text messages from Amy saying how well he was doing, videos of him playing in the yard with the other dogs. This totally and completely put our mind at ease. When we picked him up after our vacation, I pulled up to Amy's yard to see him sitting in her picture window with his dog. And again, this just solidified the fact that we would definitely coming back here. We've used Amy subsequent times before for other vacations. I've recommended her to other residents in Newington, and having lived in this town for my entire life, I've never been to any of these meetings, but I'm here tonight in absolute support of allowing in-home daycare. Thank you.
Anyone else, please?
My name is Joseph Tomiso. I live at 87 West Hartford Road. I'm not only a client of Amy's, but I'm also her brother-in-law. Last year, when she went on vacation, her sister and I went to her house a few times during the week to water her plants and feed her daughter's rabbits, who were still there. So there were no dogs around, but in her backyard, in the middle of the day, for about 15 minutes, all you could hear in every direction was dogs barking. There was no cars going by, there was no road noise, but dogs barking with nobody stopping them. But anytime that I've been to Amy's house where there's been client dogs there, we go there for family parties sometimes. If dogs are barking in the backyard, it's stopped immediately. There's no noise coming from her backyard. The dogs are playing, they're having fun. If they bark, they go inside. And I really don't see how anybody can make a complaint about the way that she runs things, because the entire neighborhood was just a cacophony of dog barking, which is normal because that's what dogs do, but she stops it when it's happening in her yard. Thank you.
Good evening. I'm Geraldine Nagel, 1175 Willard Avenue in Newington. And we have gotten a dog, which was a golden retriever, actually from Jeff Wright when he was going to Texas. And we had this dog and we want to go on vacation, and we found Amy Berube on the internet. And everything that you had said, she does the same thing. She has to meet the dog has to meet everybody else. And my dog has passed away in 2012, and this is the only picture I have of my dog, which Amy took and sent to me when I was on vacation. I think that she should have the ability to run a business that's as great as hers in Newington. Thank you.
Anyone else? Please come forward.
My name is John Colton of 190 Ballard Drive in West Hartford. I'm a client of Amy's. I'd like to ask the Commission that the minutes, proceedings, and testimony of the prior hearing on home occupation be included in the minutes for this meeting, as they cite reasons why home doggy daycare is needed. Thank you.
Good evening, everyone. I am Erica Thurman, and I live at 105 Gilbert Road. And I am here, and I want to say that I support Amy Berube's business, as well as the the testament that her attorney has put together. I think it does answer all the concerns the commissioners have, and that's it.
Anyone else? Please come forward, state your name and address. Okay, seeing none. Anyone here wishing to speak in opposition to this application, please come forward, state your name and address for the record, and limit your remarks to 2 minutes, please.
Hi. Rosemary Lindberg, 66 Bon Air Avenue here in Newington. I do not believe this type of in-home business should be conducted in residential neighborhoods. A Google search of surrounding towns indicates that such businesses are located in commercially zoned areas. However, if you intend to pursue it, then I have to say there are two key points which I find of utmost concern in formulating the zoning amendment: protection for the dog's well-being and quality of life for the neighborhoods. Such concerns include the maximum number of dogs. This should be a definitive number, including the operator's own dogs. Otherwise, there could potentially be many more dogs than just 4 or 5. Yard size. There is no mention of a minimum lot or yard size. An area of less than 1/4 of an acre minus the square footage of the house and garage is too small to accommodate a large number of small dogs or a small number of large dogs. It would not be healthy for the dogs nor safe for the neighborhood. Number of centers. There's no limit to the number of daycare centers allowed within a 1-mile radius. A neighborhood could be subjected to multiple facilities in close proximity, leading to a negative impact on the quality of life for residents. On-site operator. There is no stipulation for the operator to be on site at all times. There is the potential for an unscrupulous person to take in dogs, leave them outside, and go to work. The dogs would be uncared for, and the residents would be subjected to all sorts of problems, such as excessive barking or escaping. Excessive barking is a vague term. What might be ignored by a dog care provider may be an extreme nuisance to a neighbor. Overnight stays. According to the Department of Agriculture, one dog staying over for one night changes the facility from a daycare center to a kennel/boarding facility subjected to a different set of rules and regulations. Revocation of permit. What would be the limit of complaints or infractions allowed before the zoning board would be compelled to pull an operator's permit? Again, this is indeed uncharted territory, and if you should decide to proceed with this change, then now is the time to tighten the controls and set the parameters for this type of business. No business should be allowed to negatively impact the quality of life or safety for the surrounding neighbors. Thank you.
Thank you. Anyone else wishing to speak in opposition to this application, please come forward, state your name and address for the record. And I'm sorry, you have 3 minutes to speak as a person in opposition, not 2 minutes.
Thank you. My name is William Lindberg. I live at 116 Hickory Hill Lane. I want to thank you for the opportunity to express my opinions and my opposition to the proposed zoning regulation for in-house dog care known as doggy daycare. This regulation was written by Amy Berube, and her turn-in is slanted to fit her needs and her needs only. This commission should be considering the ramifications of all potential doggy daycare applicants and not just Ms. Berube. For example, the regulation states the facility shall not exceed the maximum number of 5 dogs, including the owner's personal dogs. How many personal dogs is that? Ms. Berube has indicated she has 2. Supposing your neighbor opens a doggy daycare, and they are a dog lover, and they have 4. You now have 9 dogs in the yard next to you. 7 is bad enough, 9 would be intolerable. There should be an added limit on the regulation so that there is a particular limit. The regulation also references up there that a fence should encompass the entire area where the dogs are kept. What kind of fence? A 4-foot chain link fence? A 6-foot stockade fence? A 4-foot fence would not keep a large breed dog in the yard. Could easily jump a 4-foot fence. In addition, there is no mention of the size of the owner's yard. As you know and has been mentioned, there are plots in town that are only 1/5 of an acre. Is it reasonable to have 7 dogs or more confined to such a small space? A German Shepherd or a Lab needs much more room than a Yorkie. Again, this regulation is slanted at one daycare owner. And what about someone who has larger dogs? What happens when the dog or the dogs leave the premises, destroy property, or worse, attack someone? There's no mention in this regulation of responsibility or insurance. The daycare owner's home insurance may not cover such an occurrence, as the homeowner's insurance is not a business insurance. This is another example of bias of this regulation. Why is there no mention of liability or business insurance? There is also a reference up there to dogs being dropped off and picked up. It is specific that only one dog may be dropped off or picked up at a time. What happens if the client has multiple dogs? Does the client drop off one dog, drive around the neighborhood, come back and drop off the second? What happens when multiple clients arrive at the same time and ignore the drop-off or pickup schedule? Does the daycare owner run out and tell them they have to circle the neighborhood until it's their turn? Of course not. This point is unenforceable and is merely added to placate anyone who is concerned about the increase of traffic in their neighborhood. It is meaningless. No excessive barking shall be permitted outside the residence. What is excessive barking? And who determines that it is excessive? This is an important point. It should come as no surprise to anyone that dogs bark. They bark when they're happy, they bark when they're angry, they bark to communicate.
Please try to wrap it up here. Yeah.
All right, when 5 or 6 or 7 or more dogs are in one yard, they're going to bark. It is going to be excessive. This is a business, and that is exactly what it is, a business. Newington has business districts where businesses are conducted. The daycare is a business and should be limited to those areas. Finally, I want to bring up to your attention an item that has not been mentioned at all, and that is a definite negative effect to the neighborhood. Property values. Property values will go down, whether from signs on the front lawn advertising the daycare or the constant noise from a pack of dogs barking behind a fence. The resale value of your home will be reduced as there will be fewer potential buyers who will want to live in a barking neighborhood. Thank you for your time.
Anyone else wishing to speak in opposition to this application, please come forward, state your name and address for the record.
Mr. Chairman, I have a couple of comments that came in via email. It might be good to read them now to get them in the record with the other comments.
Could you please read them into the record?
Okay. This first one is from Dave Bennett. I don't know his address. Hi, Craig. I'm not sure if I'll be able to attend the zoning meeting in March, but I wanted to give my feedback on the proposed zoning amendment about allowing in-home dog care. I have to take issue with this because I feel it will impact quality of life. My next-door neighbor has 3 dogs, and despite what the law may say, it is impossible for me to have the authorities enforce the law when it comes to their dogs barking constantly to the point where it can be heard inside my home. I can only imagine a similar situation could occur if up to 5 dogs were allowed for in-home care. In-home care in addition to any pet dogs of the resident. It's basically allowing a dog kennel in a residential neighborhood, and despite the restrictions within putting the enforcement of the provisions on the neighboring homeowners. I feel this is foolhardy and will negatively impact quality of life and property values. And signed, Dave. And then I also received an email from Neil Pade, resident of Newington. Thanks, Craig. After our last discussion, I was considering whether or not we should address this more specifically here, and this draft is very helpful. That's a reference to the draft amendment I sent to him. I'm a dog lover, and I think the proposed business use in a residential neighborhood has the potential to provide a valuable and convenient service if located on the right property. However, if one of these was permitted within the context of the subdivision I live in and others here, I could foresee issues, so the special permit evaluation is appropriate. The concerns I have relate to someone having to live or own property next to a potential nuisance. The standards seem appropriate and reasonable. The ones that prescribe procedures might be difficult to enforce. Was the possibility of specifying a, quote, solid, unquote, fence and minimum fence height considered for section 3.4.10b? At some point, you could have a neighbor complain that they can see the dogs in the backyard because their lot is higher than the one where the use is occurring, or they're on an elevated surface, like a deck or a second-story window. Specifying standards on the fence might alleviate difficulties in enforcement. I'm still concerned on storage and concentration of waste on the property. If stored in bulk near a shared lot line, it could become an issue fast. Also, still don't know how to handle the pre-drop-off and post-pickup habits of patrons, which tend to be to have their dog go at those times, which may create a concentration issue out of the street frontage / front yards for the neighbors. Was there any discussion on having the operators of the use having to sweep the neighborhood for waste every so many days? That all being said, I'm not aware if there's a rule that would keep a single-family homeowner from simply owning the same number of dogs allowed by the maximum, which would likely have the same issue without the business transaction. Thanks for letting me review the draft.
Any more?
That's all. That's all I've received.
Okay. This application, Commissioner comments at this point? What is the pleasure of the Commission? I would recommend that we close the hearing and move this to...
Mr. Chairman, before you do that?
Point of order, Mr. Chairman. I believe the
I'm sorry.
applicant has a right to rebuttal.
Yeah, I'm sorry. The applicant has a 5-minute rebuttal, and the person that's speaking in opposition, one of you could come up and rebut her rebuttal.
I think the most important thing to keep in mind with regard to this proposed regulation is it's still a special permit review. If this regulation is adopted, anybody who wishes to establish a home daycare operation in their house has to come before you and go through and be subjected to a full public hearing. With special permits, you have the right to condition the final decision that you make to include any safeguards that are necessary. Your special permit regulations allow you to look at all safeguards to protect adjacent property and the neighborhood in general from detriment, including but not limited to proper buffering. The size and type of the application is critical to your review. I think as well as traffic considerations, and ultimately the need for the proposed use in the proposed location. This is all under the requirements you have to look at under Section 5.2 of your special permit procedures. So it's not that just by adopting this regulation, you are not opening the door to some of the horrors that were envisioned by some of the members who spoke, or members of the public who spoke out tonight. You have the ability to determine whether a particular application is appropriate for the place that it is proposed for, or whether you can make it suitable for the neighborhood with applying certain conditions. Those would control such things as height of the fence, if you felt that the proposed fence was not high enough, or other items that were mentioned in the opposition comments. If an applicant already has 15 dogs and you have no limitation in Newington as to how many dogs you already have, you might decide it would be an inappropriate spot to run a home occupation. That is something that is decided on a case-by-case basis. You have that control. I think the most important thing for you to keep in mind, because you heard I think it was 3 nights of testimony from people with regard to the existing operation by Ms. Berube, that neighbors, even though they were there for 6 years, many of them did not even know a home occupation for dog care was being conducted. That underscores the point that it's possible to have such a use in a residential zone by special permit, and have a use that works. It meets your plan of conservation and development to support someone like Ms. Berube, who is a stay-at-home mom, a dog lover, serves a need in the community, and this regulation will allow that to happen with all the safeguards that you have suggested are important to you. So, I mean, you can conjure up the kind of situation that you would not want next to you. Don't approve that application if it comes in before you per the special permit process. But Amy has shown you that it can work quietly, sensibly, professionally, cleanly, safely in a neighborhood. And I think that is more evidence than anything else anybody could come up and say, and again, frighten you with possible scenarios. So I'm going to look at Amy and see if there's anything else she wants on the record. Pardon me? Oh, and Amy notes that, of course, if you wanted to put a requirement in there for liability insurance, that's fine, but you could require that as part of a special permit. She just asked me to note for the record that she certainly has it for her business now, currently. So that's it. I like Mr. Pate. I've worked with him I used to be counsel for the town of Canton's Planning and Zoning Commission. I mean, his comments, I think, were interesting, but you can control everything that he talked about. And this idea of, for instance, accumulating a poop pile on the side of the fence inside makes absolutely no sense. I mean, you can control those types of things, and you know that Amy controls those, as one would presume another facility would. And you also know that we would need to be licensed. Anybody who comes in under this would have to be licensed by the state also, which is an added level of protection for you with regard to impacts that it might have, particularly with regard to dog safety and cleanliness in the neighborhood. So unless there's anything else, I think we rest our case. And again, Per your suggestion, we've brought an application forward that we think meets all of your concerns, provides the protections that you need to be able to allow this as a home-based business in residential zones after a thorough public hearing review by this commission. I hope you can approve it. Thank you.
Okay. One of the persons that spoke in opposition, you could come forward and with the last word for a rebuttal. Either one of you two people, if you wish to come forward.
No, thank you.
Anyone in opposition wishing to come forward and rebut? Seeing none, now we'll go ask the commission.
Planners report?
Yes, I would like to mention one thing. I was asked to take a look at the zoning regulations of 10 nearby towns. I prepared that summary. The commission members have it. I believe I gave the applicants a copy of it. It's on a spreadsheet. I did give it to you? Right, okay, I want to make sure I did. We could go over it right now if the commission wants to, but I just want to make sure that it's on the record as information that the commissioners have.
I would suggest that you make it part of the record by reading, at least summarizing.
Okay,
or-
I can do that quickly.
or giving us an update so that the public has an idea of what work you've done on behalf of the commission to look at other towns.
Right, okay. The 10 towns that I was asked to look at are Rocky Hill, Middletown, Bristol, Simsbury, New Britain, Cromwell, Berlin, Weathersfield, Glastonbury, and West Hartford. The first item I looked into was whether dog kennels are defined in the zoning regulations. Rocky Hill, they're defined but not regulated. Middletown, no definition. Bristol, defined and allowed in commercial zones and by special permit in residential zones, but only with at least 2 acres. Simsbury, they're in the regulations, but they're not defined, and they are specifically prohibited in residential zones. New Britain, dog kennels are not defined, but you do need a Department of Agriculture kennel license if you want to be a dog breeder. Cromwell, they are defined, but they're only allowed in connection with a farm. Berlin, dog kennels are allowed and zoned they're in the regulations by special permit in commercial zones. Weathersfield, yes, allowed in commercial zones. Glastonbury, yes, by special permit in commercial zones. And in West Hartford, yes, by right in commercial zones. And then as far as home occupation regs are concerned, and this question is just, do these towns have home occupation regulations? And the answer for Rocky Hill is yes. Middletown, yes. Bristol has home occupation regulations, but, quote, animal hospitals are specifically not allowable as a home occupation. Simsbury allows home occupations. New Britain does. Cromwell allows them, as do Berlin, Weathersfield, Glastonbury, and West Hartford. So everybody pretty much allows home occupations. But of the ones that do allow they all allow home occupations. And then I was asked to research whether, if they allow home occupations, are dog sitting or boarding mentioned, and dog sitting / boarding is not mentioned in any of those towns. But West Hartford does go on to say that in West Hartford, any home occupation activity must require, quote, specialized knowledge derived from long and intensive academic preparation or work that's original or creative in character. So obviously pet care would not be allowed in West Hartford as a home occupation. And then the final thing I was asked to look at is whether there's other language in these towns' zoning regulations that might some other way allow dog sitting or boarding. And there's nothing to that effect in either Rocky Hill or Middletown or Bristol. In Simsbury, pet daycare is defined, but it's not regulated. Simsbury is also the only town I found that limits the number of dogs that a homeowner can have, and they limit it to 6. New Britain doesn't say anything else about dog sitting or boarding. Cromwell does allow dog sitting or boarding, but only in the local business zone. And Berlin doesn't say anything about it other than it's not mentioned. Weathersfield does talk about the keeping of pets and livestock when not in compliance with the above provisions is allowed by special permit in residential zones. So it sounds like Weathersfield has already sort of adopted the type of amendment that's being discussed tonight. Glastonbury and West Hartford do not say anything in their zoning regulations about dog sitting or boarding otherwise. So that's, that plus those two items that I previously read are all that I have for the commissioners.
It's up to the commission to determine whether you want to shut the hearing off. I would recommend that we close the hearing and move it to the next meeting for deliberation, possible action. Can I get a motion to that effect, or some type of a motion?
Sure. Go ahead and move that we close the public hearing on this application.
Motion made.
Second.
Second.
Motion made and second. Any comments from the commissioner?
No.
on the motion? Hearing none. All in favor?
Aye.
Aye.
Opposed? Okay. That ends this portion of Act 1 application. We also have the other part of it, the home occupation, which is still open. Have the applicant come forward and see if there's anything new that she wants to add to that, or could we proceed to close that and also move that to old business?
Mr. Chairman, Robin Pearson for the record, on behalf of the applicant. No, we have nothing further to add. I think we've gone through an exhaustive proceeding with that, except for I will put on the record, as we just discussed, our concern for Mr. Payne sitting on and deliberating on this application. I understand he has already put on the record that he will not recuse himself, which is fine, but it's incumbent upon me to put the notice that I previously provided, I'm handing it to the secretary, which is the complaint that was filed by Nicole Payne with regard to the home occupation use, and I asked that the information that I previously submitted be included in the record on that particular proceeding. So with that, we certainly hope that you would be able to approve her application for a home occupation, and if not, hopefully, as we previously said, you would approve the application for, or approve the text amendment application. So thank you very much.
Mr. Planner,
I have one new item to add. Several meetings ago, I was asked by the commission to contact my colleagues to ask them whether the towns that they work in would a home daycare be allowed under home occupation permit, which is a slightly different question from doing my analysis of their regulations. And I got 4 responses, and I'll just summarize it. 2 of my colleagues in their towns said that they didn't think that their TPZ would allow a doggy daycare as a home occupation. The other 2 planners said, yes, they thought that their town would consider it, would consider a doggy daycare as a home occupation. So I just wanted to put that on the record.
In fact, if I may, looking at that, I note that Neil Page specifically, who was the one that did the review of the text amendment for you, indicated in a transmittal to you on February 1, hi Craig, I believe one would be allowed under our home-based business regulations, section 512. So I just add that, thank you.
in the business zone.
No,
No.
home-based,
Home occupation.
home occupation. Thank you.
We have to open it up to public. Yeah, okay. At this point, we'll open it up to the public. If there's anything new that you want to add to the record, please come forward, state your name and address, that people are in favor. Anyone? We've heard this for 4 meetings. We know who came, we know what your sentiment is. Anyone? Anyone wish to speak in opposition? Seeing none.
I'll make a motion, Mr. Chairman, again for petition 3417 to close the public hearing.
Second.
Motion made, second. Any commissioner comments? All in favor?
Aye.
Aye.
Opposed? Okay. That ends that portion of the public hearing. We have another.
Mr. Chairman, I'm sorry, do you want to do that as old business tonight or next month? Or
month.
next meeting?
We're doing both at the same.
Next meeting?
Yeah.
Okay.
We have to deliberate on.
Right.
Next item on the agenda, would you read petition 0418?
Petition 04-18, special permit, recreation use at 80 Fen Road, Montana Knights Axe Throwing, applicant 80 Fen Road, LLC, owner Merle McKenzie, 1183 Killingworth Road, Higginham, Connecticut. Contact.
Wait just a minute so that the room can clear for the people that heard the last application, so that we could proceed with this application. We see you got a big article in the Hartford Courant this morning.
Yes, I did.
It's a nice article.
Thank you. Good to go?
Yeah, I believe you can proceed.
My name is Merle McKenzie, and I live at 1183 Killingworth Road in Higginham, Connecticut. And I'm here to discuss 80 Fen Road and my desire to ask your permission for an approval of a recreation use at 80 Fen. With that, I'd like to give you just a couple of handouts, if I may. So the picture of what I'd like to build with your permission and some examples of other facilities around the country.
Before you start, is the owner of the property here?
No, but I believe his realtor and representative was supposed to be
Is
here.
there someone that represents the...
I'm actually here on the owner's behalf.
Okay, so someone's here to answer questions about the site plan and that go along with your application?
Yes, sir.
Okay, thank you. You can proceed, go ahead.
So just a very short brief history on the sport of axe throwing. This is something that emanated out of Canada decades ago, mostly through the use of backyard leagues. About 10 years ago, somebody decided to turn it into an indoor sport. It's been gaining popularity both across Canada and now recently in the United States. There's franchises and single owners like myself who are opening in most of the major markets in the United States. And to my knowledge, I'd be the first one in Connecticut. That's what I'm asking your approval for tonight. My vision of it is a family recreational use, something where we'd have kids' birthday parties, Cub Scout attendees. I've actually been emailed by several Cub Scout leaders looking to come if we should get it approved, corporate events, leagues, and such. With that, I'll be painfully short in my presentation.
That's okay.
And I'm going to turn it over to any questions you may have, and I may be able to kind of flesh that out in a little better detail if you do have any questions.
Okay. I'll go ahead, Stan, you could
No,
start.
go ahead, Frank.
Is there a food operation in conjunction with the axe throwing operation?
No, sir.
So there's no liquor, beer and wine or liquor permits?
I haven't gotten to that point yet. If it comes up in the future, it's something that I guess I'd have to come back before the committee and seek approval for.
I was surprised that you said there's no food operation, because I would think that would be a big part of that business.
It may be, but I don't want to be responsible for the health regulations for it, nor do I want the additional startup costs that come with trying to provide a kitchen. I mean, we may sell potato chips or something like that, allow people to bring their own food if they desire, but I don't want to be responsible for it.
Okay, well, that was a question that some of the commissioners had, and, Stan, you got a question?
Yes, one quick question.
The person that's going to be the instructor for the axe throwing,
Yes, sir.
does he have some type of training in this?
Yeah, it'll be done by myself personally. There's no official axe throwing school you could send somebody to. It's done all in-house by the proprietors of such businesses.
I guess I'm concerned with is that long as the person that's running that particular range or port knows what the safety regulations are.
Yes.
And then that kind of leads me to the second thing. I noticed on one of the pictures you had back there, looks like you have 2 ports open. Is that how they normally are done, or is it individual ports? I saw one picture had like individual ports with screened off areas.
Right.
Then I saw the picture just went this way here at like 2 ports.
So with respect to the safety, all regulations will be posted both on our website and at the venue in front of the axe throwing ranges. They'll be guided by an expert, so to speak, and that expert will come and stay with the party the entire time they're there. They're not to leave while the axe throwing is going on, and they're to oversee both the enjoyment of it and also safety venues. With respect to your question about the 1 target or 2 targets, to my knowledge, it's typical that there are 2 target ranges in pretty much every facility that I've been to or have researched.
Now, I'm just curious, so now one person would be coaching this particular port, another person would be coaching this particular port over here, is that correct?
So
if you have the picture I saw had 2
here we go.
ports.
So this is helpful here. So what happens here is traditionally there's 2 people throwing at the exact same time with the expert in the cage. So the rest of the party is behind another wall. 2 people are called up. 3, 2, 1, go. They throw the axe. Once the axes are either stuck in the target or have fallen to the floor, then the expert will give them permission to go retrieve the axe. And once the 2 participants are done, they move out and the next 2 participants come in.
All right, that's my question. Thank you.
You're welcome.
Any other, Steve?
Mr. Chairman, actually, probably through you to the town planner, more about parking. Is there sufficient parking on the site for, I mean, we had a very old site plan, which didn't show very much. I just want to make sure that there's, all the parking meets the requirements for this application.
Right. There is enough room on the property for sufficient parking. However, much of that room, is not striped, it's not paved. But my understanding is the landlord has told the tenant that if approved, he will provide the amount of parking required by the town. So if the commission is inclined to approve it, I would recommend that it be approved with the stipulation that in fact the landlord provides sufficient paved, striped parking.
Okay, thank you. Thank you.
Mike, if you could, you're familiar with what we approved in the past for this application. Okay. Is the work that we approved under the last site, under the site plan, has it all been completed? Can you tell us what the deficiencies are and what we have to do to get the owner to participate in getting the site plan up to stuff so that we could take into consideration this applicant?
Yeah, so the site plan that's on the screen is the modification that was approved. It shows the driveway being relocated to the north of the lot. That has been done. The south driveway has been largely abandoned. Most of the blacktop has been removed, but the curb cut still exists. So from our perspective, certainly the landscaping needs to be addressed. The curb cut needs to be closed. The parking lot that is, the blacktop that's shown in the front here of the building on the west side needs to be brought up to spec on striping. And I believe there was some hydrant relocation that was originally talked about, and I'm not certain if that's done. But everything on the north of the building to accommodate the tenant that's in the building now has been complete.
Okay.
Next question.
This is Anthony has a question. Go ahead.
Hey, thank you. On that site plan that we're looking at right now, does the driveway, if you look at you're looking from Fen Road at the building, the front left corner, Michael, you're telling me that the pavement goes from that front corner all the way up to where, let's say, the existing bituminous gravel driveway slash marks start?
I think are you referring to this area here? Here, maybe what I can do is,
I'm referring to the area, I'm looking at, documents I'm looking at have.
is that better?
On Penn Road, looking at the building, I see it says, flat top elevation, 100.50. See it like in the front of the building there?
So this portion of the portion of the driveway to the west of the building, when then the hash mark, that was to be removed. The hash mark shows.
No, I know, and that's what I understand that, but you just said that the whole area in front of the building is paved now. And my question is, if I go to that front left corner of the building, meaning the point when I'm standing on Fenn Road looking at the building, would be that basically the center of the plan I'm looking at, that corner of the building, if I walk off that, which is called the grass area, and that whole parking lot's paved in the front of the building?
I don't believe it is.
I think you're referring to this portion here, and I'm displaying an aerial image right now.
He can't see what you have.
But I guess we can answer it this way. We've gone over this with the applicant and the owner's representative, and they've agreed to I think, and correct me if I'm wrong, to bring the property into full compliance with the approved site plan should it be approved. So if that was a condition, we would certainly.
Okay, and that generates my question. So what I'm looking at on my computer now, the PDF file of what was digitally sent out and in the mail, is the current, this was my question, the current operation of that lot, is that driveway paved currently the way I'm looking at it?
The specific the driveway on the north section, the new
driveway, the lot, the pavement, the parking area, everything. Because you just stated that you went out there and it looks what you looked at on this drawing, minus some, grassy areas that haven't closed out the existing driveway.
I might be able to speak to that. I might be able to help you out. I've been on the property, and the new existing requirement for a driveway, that is paved. David, sorry, you can verify that?
That's correct.
It's paved from the front of the road all the way to the back of the building, and then there's an old existing paved area directly in front of the building, and yeah, so it is paved.
And when you use the word front of building, I'm using the terminology of the front of the building. As I look at the building from Fenn Road, that maybe width of the building is maybe 50 feet. So in front of that, there's like an old white door that you look at, like maybe an 8 by 10. Is there pavement in front of that, or just rocks?
There's existing paving in front of that is going to be improved on, increased, and to the left of that is the driveway entrance from Fenn Road back to a fenced-in area for the tenants that are in the back of the building.
Exactly. So the only paved area in front of that fence is an area where they park the 18-wheelers. There's no pavement in front of that. There's a white door, an 8 by 10
there is
door
pavement in front of that, I believe. It does definitely needs to be increased in order to reach the amount of parking spots that I need. The owners assured me that it'll be in compliance should you approve it.
But we don't do, okay. So Mike D'Amato, do we have a copy of the proposed, or are we going to get that after tonight's hearing?
The proposed site plan?
Yes.
The site plan that they would be using to bring the property into compliance is what was approved by TPZ probably a year or two ago.
Okay, and so the site plan I'm looking at right now counts out roughly 20 parking spaces, 25 parking spaces.
Right, and that's not enough. So what they're going to have to do, if approved, is stripe what's now rubble, as I recall, just like broken up old pavement to the west of the building. That will have to be
And
striped.
resubmit that site plan then, correct?
What's that?
And they would then have to resubmit that site plan.
No, well, you can certainly make that a condition of approval that they submit a revised site plan showing parking stripes so that we can verify that they are creating enough parking spaces for this use.
Planner Minor, that is exactly the question I had presented to you in your office.
Yes, you can ask them to do that.
This would have to be resubmitted because it's a change to the approved
Oh,
site
no,
plan.
that,
for
oh,
structure.
okay, that's why I'm glad we're clear.
Correct?
No, they don't need to, they don't need to go through the formal site plan modification process to show
What?
stripes on a map. I mean, that seems.
But you're
excessive.
adding a section of parking, AKA pavement, that is not currently at the site today.
Well, it's currently paved, it's just not striped.
No, okay. All right. We can agree to disagree. Thank you.
Okay,
Hey, Mike,
Camilo?
when we approved that site plan, there were catch basins on the northeast side where the loading dock is. And it's drained into a brook that runs back into the highway department property. There's supposed to be dry wells there for any type of pollution to catch that. When's that done?
We've not done any formal certificate of zoning compliance. There's no bond that's on, so there's not been a formal inspection where we've gone through and checked everything with engineering to make sure that all that's done. What would happen is after the work is completed, we will go out and take a look and we will verify with engineering that all that had happened. We haven't done that yet.
While that was being installed, when we had looked at it, because it is environmental, we don't need any more problems in town.
Yeah, I wouldn't have looked at it. I'm not sure if there was a condition on the site plan that the engineering department review it. I don't know specific for this off the top of my head, but it's possible that that was done. I'm not sure.
When they have a certificate of occupancy for the person that's in the building now?
So the challenge with this property is that there was no new certificate of occupancy that was issued, I believe. So they didn't, because I sign those and I issue the certificates of zoning compliance when I get the CO request. But we did not receive a CO request for this, so we didn't have any involvement in the occupancy of the rear two units, which is why we.
Can I ask a question, Mr. Chairman?
Yes, go ahead, Anthony.
So my question on this is that the occupant who's occupying it without an approved site plan.
They have an approved site plan, Anthony, but it's not,
Okay.
it's never been completed. They never asked for a certificate of occupancy. So when they never asked for a certificate of occupancy, they moved into the building, but we've never inspected because we weren't required to unless we got the request for the certificate of occupancy. Is that correct?
Yeah, there wasn't one required.
Thank you, Chairman Ida. Thank you.
So we have to bring this property up to specifications for what was approved on this original site plan for him to be able to proceed with renting or getting the rest of this done. Hope you relay that back to the owner, that the conditions of the approval or whatever would be based on that site plan being done before they moved in. We're going to be stringent on giving a certificate of occupancy until this work is done. You skated under the radar with the person in the back as they're in the building operating without the benefit of a certificate of occupancy, without the benefit of a completed site plan. So we'll put that behind us. Let's get it up to where it's supposed to be, relay that back to the owner, and let us be able to proceed with this application. We're going to need enough paved parking for the requirements of the regulation, and the planner and the zoning enforcement officer will determine what that number is. That's why we asked, is there food concessions there? Is there liquor concessions there? You don't plan on having food trucks or anything like that there?
No, sir.
Okay. Because all of those things are related to how much parking we require you to have. If you're running it as an operation with food, we're gonna look at the parking requirements in a different light than if it's just recreation. We'll look at our regulations specific as to the uses.
No food, sir. And again, I'll reiterate that the owner has indicated that the rest of the work that needs to be done to bring that site plan into compliance and to accommodate my parking, he's already verbally agreed to that. It's a condition of me renting the building. So I see no reason why it won't be done, because otherwise I'm not going to pay him.
Well, you won't get a certificate of occupancy, you won't be able to occupy the building, because we'll be watching it this time.
Well, that's kind of what I meant.
Okay. Any other questions for the applicant? Okay, if you have nothing else, it's a public hearing. We'll open it up for people who wish to speak in favor of the application. Please come forward, state your name and address for the record.
Thank you very much for your consideration.
You're welcome.
Hello. I just want to thank the commission for your time. My name is Jesse McKenzie. I reside at 164 Eddy Lane here in Newington, Connecticut. Lifelong resident, went to Newington High School. I'm a millennial, and I just want to come in and express my interest in this place. It sounds wonderful. I admittedly do know the business owner. I am his son, and I've been fortunate enough to watch him build business after business and be successful, and there's no reason to see why that wouldn't be the case here. A couple of years ago, about a year and a half ago, I would say, actually, I went to a place called Stumpy's Hatchet House in New Jersey, which is what this place is. It was an unbelievable experience. The place is thriving with young people and families and everything you would kind of want to see in this type of business, and I think it would be positive for the community. Thank you.
Anyone else?
Good evening. My name is Joe Millette. I'm one of the principals of Big Sky Fitness. We have the property at 58 Commerce. It's been a while since I've had to stand in front of you guys. I support the proposal. I think it's a great idea. I have 3 reasons for supporting it. We've been in town for, since '01, so 17 years. That property's been an eyesore for quite a while. So to see it finished would be great, because our customers are driving by there every day. I think the family use idea is great. I think he'll create jobs, which we're all about right now. My understanding from Mr. McKenzie is he'd create about 12 jobs, which is great. And of course, tax base. Anything we can do that helps our tax base and helps us reinvest into our community, I think is great. My only stipulation, if I may, I would say I agree with the gentleman on the PA system. Is that a commission member?
Yes, it's Commissioner Claffey.
I understand his concerns. I agree with him. I think when somebody skates under the wire like this, it creates a problem for all of us, because you're half done and it doesn't look good for any of the business owners in the area. So my contingencies would be that the owner has to satisfy your requirements in the site plan, and my suggestion to Mr. McKenzie would be to make sure that your lease is contingent upon the C of O, so he holds to that pressure, because the tenant that's in that building right now did not get the product that he was promised. Other than that, I support it. Thank you.
Thank you. Anyone else?
May I make a comment real quick,
Yes,
Commissioner?
go ahead, Anthony. You can make a comment.
I just want to bring it up that I didn't know my name would be brought up, but I am a member of Sky Fitness, and I had no knowledge that I would be a member of a group where a member of the community came and spoke in behalf outside of what we're talking about. So I did not know I'm just saying there's no conflict of interest in that. I don't want it to turn the opposite way, like a previous public hearing.
Okay. So noted for the record. Thank you, Anthony.
Okay?
How you doing? My name is Scott Skates, one of the owners of Image Inc. and 102 Payne Road. I live at 23 Oak Ridge Drive in Berlin, Connecticut. I just came before you tonight to speak on behalf of Merle, just to give you an idea what kind of businessman he is. I've known him for 20 years. He's had multiple businesses. We've done tons of different projects with him. Great person in the community. I know the axe throwing thing seems kind of maybe unique or new, but I've known Merle since the days where one of his first businesses I showed up to see him at was people lifting up rocks off ground, lifting up wheelbarrows, throwing rocks against the wall, and I'm like, this later obviously turned out to be the CrossFit craze. So back 20 years ago, Merle was an innovator with some of these new things that people might look at and say, oh, that's never gonna fly, that's called yard work. Well, obviously turned that into a successful business, and I'm sure this axe throwing thing, from what we see, looks like a great idea. And I'm supporting just another business. He's a classic example of trickle-down economics. He does well, we do well, somebody else does well. So that's well under the 2 minutes too, so.
Very good. Thank you.
Thank you.
Anyone else?
Hello, my name is Connor O'Rourke. I'm from Middletown. I had the opportunity 2 weeks ago to the Arnold Schwarzenegger Classic in Ohio. And in Columbus, Ohio, there was an axe throwing house that I went to, Columbus. Went there for 2 hours. I had the time of my life. There were 2 parties involved. I was in one party on the left, and there was a corporate party going on the right. And both sides had, I feel, had equal amount of fun, and I feel that this would something that would be a positive for Newington. Although I live in Middletown, I come through the Berlin Turnpike to do most of my shopping, whether it's at Target, Puerto Vallarta for entertainment. I see my vet out here. I would like to continue that. And I feel that coming to this place would be a great opportunity to extend that. Thank you.
Welcome. Anyone else?
Thank you all. My name,
Hang on, she changed the tape so we get it on record.
Sure. Thank you very much. My name is Robert LaRocco. I'm a resident at 74 Harvest Court in Newington. I've known Merle for many years. I've been a student of his at his gyms that he's owned and operated rather successfully. I really see this as really kind of the new archery, bringing a little bit of life to an abandoned site, so to speak. So obviously, I'm well in favor of having a thriving business as opposed to some abandoned industrial building. I think would be a positive for that area, and I am in favor of the business. Thank you.
Good evening. My name is Mike Phelps. I live at 108 Tremont Street in Newington. I've known Merle personally for over 10 years. I've seen him bring CrossFit gyms to several locations in Connecticut, including Berlin, West Hartford, and Glastonbury. Before it became popular, he was able to launch those businesses successfully and create new jobs and opportunity within those communities that he has opened businesses. He's very passionate about the businesses that he's involved in, and as with his past experience holding several fitness certifications, Merle puts his effort in to maintain a safe environment amongst a variety of conditions, to provide coaching at individual or group levels, and always provide positive reinforcement to his clients. So in conclusion, I feel that Merle's talents and abilities make him well suited to this endeavor, which I support having in my town. Thank you.
Thank you. Yes, sir.
Good evening. I'm Jim Phelps. That's my son. I've been in this town for 33 years. All I'm going to say is my son summed it up well, but I want to tell you, I remember when that was Grody Chevrolet, and it was a desolate property. When we talk about revitalizing the economy, you want to put in a business that is going to be drawing people, which this will, and you also want to have an improvement to the economics and the trickle down. It does work. You gentlemen have to make the decision regarding how it fits into the town. But I will tell you this, Merle McKenzie is a man of character and good doings. I've never met an honest individual like him in my entire life, outside of my father, who's in heaven. And I will say this, he will give back to the community and make improvements that you will see. I've known him, I've worked for him, and I've seen situations where gyms have been in trouble due to Hurricane Sandy or a catastrophe. He takes money out of his pocket to help those other gyms go through. So he would be a strong asset to the business community that Newington needs to exist. I support it. I hope you gentlemen do too. Thank you for your time and consideration.
You're welcome. Anyone else?
Good evening. My name is Lisa Nilsson. I reside at 29 Clarendon Terrace. I've been a Newington resident for 29 years. I think this proposal would be a wonderful thing for our families, younger kids, older kids. I have college kids. Something for them to do, something in town. I think it would generate business as far as employment. It's a great location. The Central College is next to it, borderline to Britain, West Hartford, Newington line. I just think it would be a great opportunity. Thank you.
Anyone else wish to speak in favor of this application? Okay, seeing none, anyone wishing to speak in opposition? Okay, seeing none, we'll ask the commission to move this forward.
Mr. Chairman, I have just one thing I'd like to add for the record.
Yes.
Yeah, Commissioner Claffey is correct. The zoning regulations do say that a change in use of land or use of a structure or building will require site plan approval if any of the following occurs. Number one, increases the amount of parking. So yes, the owner unfortunately will have to go back to Tarbell, Hinz and Associates and have them prepare a revised plan showing the additional parking spaces that the commission is going to require as a condition of approval.
You're the owner's representative. You want to come forward and you understand what the planner just stated, that you're
Yes, I do.
you're going to have to make a revision to the site plan, come in, what will he have to do for?
Well, he'll have to apply for site plan modification, which means having the professional engineer show these additional stripes on the plan, submit them to the commission for approval at a TPZ meeting. There's an application fee of, I think it's $120. So there's a process that needs to be gone through.
In this be,
And what is
in
the
this
total
be
parking?
part of this application?
Not part of.
Not of it, but I don't want to hold up the.
Oh, but you can approve this with the condition that they come back for site plan modification.
I don't want to hold up them being able to move forward if we approve it. So we'll make it condition, but you're not going to be able to let them move in or do anything until, so it would be to your benefit to go start tomorrow morning and go see your engineer and decide and have them start doing a plan and get it in here as soon as possible. I mean, this is an approved use under our zoning regulations. We've researched it, the planner and I discussed it. I discussed it with the zoning enforcement officer. We have no experience with this type of an operation, and we've determined that it fits into our regulations as an entertainment venue. So there is provisions in our regulations to approve this type of an operation, if it meets all the conditions parking, zone, landscape, and so on. But a lot of that has to do with you, not the applicant. So don't hold him up. See if you
we
can get
will
that
not.
done.
And may I ask, how many total parking spaces are required for this operation?
Mr. Planner.
Right. I think
Now,
we
keep
figured
in
something.
mind that there's no, you said that there's no food and there's no
Right.
liquor operations.
Right. As I recall, if you put parking spaces along the west wall, 9 feet apart, that would be sufficient. I think that would come to something like about 10 spaces. That would be enough.
Okay, well, the catch basin's already in place. I don't think it's going to be an issue to add those spaces.
Okay. And you're basing that on what? If you based it on, you can't base it on the square footage of the thing because the operation is 8,000 feet. So
Well, actually,
you've got to do it based on the number of lanes and the number of people. There's got to be a different formula than square footage of
yeah, actually, I was using the parking, the bowling alley requirement, because I figured
Okay.
it's analogous to a bowling alley.
yeah, and that would be sufficient.
Yes.
Okay.
Very good.
Okay.
All righty. Good.
Anything else?
That's it.
Thank you very much.
You're welcome. You want to get a motion to move this forward? Motion made and second.
Second.
Motion made and second. All in favor?
Aye.
Opposed?
Aye.
Okay, so we'll move it to the next meeting for deliberation and action. So next meeting is, I believe, April
28th.
or March.
March 28th.
March 28th is our next meeting. We'll discuss it and we'll take action. There'll be, if it is approved, there'll be conditions to the approval if it is approved. Okay. That ends the public portion of the agenda. We're going into approval of minutes.
Make a motion to approve the minutes.
Motion made, second. Any additions, corrections? All in favor?
Aye.
Opposed? Okay, we're into new business. We're going right into Newington Ridge Reserve. We have the town attorneys here to answer any questions. There's been some correspondence today and in the last couple of days from developer to the town planner. I just put on the record that we did have a preliminary meeting with the town attorney and the planner I did to discuss what our options are. So he's here tonight but there's been some things that happened in the last 24 hours that we should bring and put on the record. So I'll turn it over to the planner first, and then I'll turn it over to the town attorney for some legal advice.
All right, I'll go first. I'll be quick. The town attorney and the chairman and I met earlier this week to discuss the TPC's options and what the issues are. And as a result of that conversation, it became apparent to me that the direction that the commission was probably going to want to go in on the recommendation of the town attorney is that if the commission calls the bond, that the commission would turn to the homeowners association to actually do the work with obviously written agreements between the two parties so that each party knows what they're required to do. So I made the homeowners association aware of that. And at the same time, I made Mass Construction aware of that. And amazingly, I got a call from Mike Massimino a few minutes later. And he was surprised that that there's an issue. I'm not sure why he was surprised, but, and he said he's not prepared to come to the meeting tonight, but that he would be willing to come to a future meeting. Actually, even before he said all that, I told him, don't talk to me, it's the commission that wants to talk to you. But then when he called me back this morning, he said that he did have the opportunity to talk to the vice chairman and that he was prepared to come to a meeting in April, but that he would not be available to come to this meeting tonight. And that's all I have to say at this moment.
Okay, well, one person doesn't make the determination for the commission makes determination as a collective body. So I leave it up to the commissioners here to give me input as to which way you would like to proceed. He is saying that he's coming in. Why don't you read that email or the communications into the record so that the people from the reserve understand what exactly he said.
Good. Okay, this email is dated 2:51 p.m. today. Craig, per our phone discussion earlier, I'm requesting that no action is taken on the current bond posted with the town of Newington in relation to the above referenced property at tonight's planning and zoning meeting. As discussed, I will not be able to attend tonight's meeting as I'm out of state in Massachusetts dealing with the blizzard from last night, but I will be attending the April 11 meeting. Prior to April 11, I will have a site plan modification application submitted and hopefully in time to be heard on April 11 to address the changes that are in agreement with our company and the homeowners association. I will also present the commission with a time frame and plan to address the current binder course, filling and grading behind Lot 1 and Lot 2, as well as any other issues or concerns the town of Newington and the homeowners association may have. As it relates to a time frame, we will mobilize within the month of April to start removing the fill. We have found a location to bring the material, and we're just waiting for the weather to improve prior to starting work. Our intention is to replace the binder course late summer after we remove the fill, install the last of the foundations, as well as any other pending site work to be completed. As discussed previously, it doesn't make sense to do this prior to the heavy site work being completed. If you or anyone has any questions, please feel free to contact me. Regards, Michael Massimino, President, Mass Construction.
Thank you. That's the communication we got back from Massimino. So I'll turn it over to the town attorney just to give us some input from the town's perspective, if you would.
Yeah, thank you, Mr. Chairman. The primary concern is that, and I don't say this lightly, but the town is not in the business of being developers, excuse me, and that if the excuse me, if the bond were pulled or taken over by the town, I am not recommending that our staff be in charge of doing the improvements to the subject property. It puts us in a precarious situation whereby we become developers, and I don't think that's appropriate under the circumstance. It's an odd situation in that we have really entirely private property. There is no public street there. There never will be a public road. And although it impacts town residents and taxpayers, and let the record show that there are people here from the association standing before me, although it does impact you tremendously, it really isn't the town's responsibility, and that what is more appropriate is that the town transfers the funds to the association with a hold harmless agreement entered into by both parties, whereby there are requirements on both parties, and basically you would be empowered to complete what has been promised to you, and the town would not be obligated to oversee it or give you advice or guidance as a respect of being a developer. Of course, you can look to staff and guidance of the building department, the town planner, and so forth, but the town would not be the developer.
I think where the town is coming from is that this is a really unique situation. If this was public roads and under different circumstances and we pulled the bond, we would be required to act as the developer, and we'd have to go out and hire a construction manager or do it in-house or something. But the situation here is because of the private nature of the road and the whole development, common areas and everything else, it puts us in a position where it's better that the association take the money and hire a construction manager I believe there's enough money there to complete all of the requirements. We'd be willing to have you make modifications to site plan, eliminate the sidewalks, the gazebo, whatever else you thought that was over expensive to meet the requirements of the money. We'd look at whatever you brought forward, but we're willing to work with you in that respect. But as far as, I believe there's enough money for you as an association to hire a professional construction manager to oversee the project and get the product that you were promised when you bought the properties. But that's something that you'd have to discuss as an association. At this point, I'm going to open it up to the commission to get an understanding from them as to how they want to proceed with this bond thing. We've gotten a lot of promises from we were told they were going to be here the first meeting in January. It's now the middle of March, and they still haven't been here. So I want some guidance from the commissioners as to which way they want to proceed. Commissioner Sobieski.
Thank you. Attorney Ancona, two questions I have that stick out. Number one, they hire a construction consultant to do the project. That has to be built to town standards that was approved by the plans. Am I correct?
Yes, you've got an original site plan somewhere, I'm assuming,
Right.
with all the specifications.
Okay. Second of all, and it's going to fall on them, but what about the flooding damage that's occurred, even though that's private property? Would that be something that would be subject to the amount of money that's being turned back? Would they be able to tap into that to take care of any flooding damage? I think one of the ladies said her basement got flooded or something.
I would have to take a closer look at that, but at first glance, I would say no.
Okay. And then the other thing is, I do agree with Commissioner Aida that no one individual should be talking to this person. It should go through one central person, like the planner, because this person here has been several times. He says he's going to show up, never shows up. We had one meeting, and I could be wrong, maybe it was two, where he showed up, and then, oh yeah, I'll be at the next meeting, and never showed up. And time after time, these people have come out asking what's going to be done. I have empathy for what they're going through, having been in the working for the DOT in construction for a while, and this is just mind-boggling to me. Thank you.
Mr. Payne.
Yeah, I agree with my fellow commissioner. It's gone on for a long time. I did receive a call from the developer, and
We're not, let me put on the record, we're not questioning you. We know where the call originated from, from the developer. He probably couldn't get a hold of me, so he called you.
yeah, I just want to explain.
So the record's clear, we're not saying anything that...
Yeah.
No, I'm not.
No, I understand. But, and I urged him to send an email off to staff. I urged him to be here tonight, that he should have been here. He explained what happened to me briefly. I told him, you better get an email off, and people are getting tired of you not showing up. So I told him that it was important that if you do set a date and time, that you should honor it. And I just want to get that on the record. Thank you.
Mr. Woods?
I got a bunch
like
of
to call
questions.
you. Get a different perspective.
Thank you. Well, actually, I'm going to come across probably sounding like I'm on the side of the developer trying to support him, and I don't think I am. I think there's a lot of things that are going on here that aren't right. But saying that, one, I believe this commission just met prior to me getting on, because I wasn't involved when he was in to you last fall. But he made commitments, and to the best of my knowledge, he did keep up some of those commitments, and then winter did fall in. And while he hasn't come, he really couldn't do anything from that time till now. So he has responded for one, and I think that's a good thing, because I think in the end they might be better off doing that. The second is that Commissioner Fox, actually at our last meeting, requested that we get the opinion in writing. I'd like to see how this process works. from start to finish. Because again, Mr. Massimino, he has rights, I'm assuming. So I need to understand how this all is going to happen. And the reason I'm asking that question is, it is my understanding that the town of Newington holds this money until the work is done. So what I'm hearing is that we're going to release the money to the association prior to the work being done with a letter of intent. I have a problem with that. Not that I think they're not going to do it, but I think that's not the reason we're holding the money. We're holding the money to make sure, in fact, that the work is done and done to whatever standards was on the approved site plan. Once that happens, if in fact the town attorney or a judge says that in fact the money can go to the association, I think it's a wonderful thing. I think they need to be able to get resolution. I don't have that answer, and I was hoping to have something in writing from you, Mr. Attorney, Mr. Ancona, or Attorney Ancona, so that could help me understand how this process works.
Well, I wish I could give you more of a detailed answer on this at this point, but this is extremely unusual. I mean, you're talking about quite a bit of money being held, and we've got a development that's not completed, and the provision of subsection 4 in the agreement makes it very clear that if the town determines that you've gone past that date, which I believe is in May of 2017, the town has every right to enter such property and make the improvements. It is my opinion that I would rather not see the town enter the property and make the improvements. I would rather see the town transfer the funds to the association to have them make the improvements, because again, as the chairman said, this is entirely private property, and there's no public nature to it. I think it's extraordinary that the town has the sum of money at all, that the protection was put in place originally. Again, Commissioner, there's a 30-day requirement. You've got to give this guy 30 days notice pursuant to the bond agreement. And I would hope, no disrespect to the association, but he's clearly, and this is, I'm not saying this as a lawyer, I'm saying as this, just a commonsensical thing to say, is that he's probably better equipped to complete the project than anybody else, should he choose to get going on it. And I think if this commission gets serious and says, we're going to do this, I would hope that he would step up and finish it. And that's just my personal opinion. Legally, I think this commission has every right to call that bond at this point and transfer it with a hold harmless agreement to the association and wish them all the best.
Mr. Chairman?
Yes.
I don't disagree with calling the bond. I have no problem with that. Notifying that the property owner or the contractor that he is in violation of the plan that we have, the site plan. But I guess what I still don't have, and I heard a little bit more of it now, that there's a 30-day notice. That's kind of what I wanted to see, just kind of spelled out how the process works. Once that notice is given, what happens? What's the timeline? What is his rebuttal? What is the association's rebuttal? You know, how that money then gets put aside so it's used for the right things. I'm not trying to be an obstructionist. I just want to make sure, A, that they get their road that they're supposed to, and anything else that that money possibly can do for them, whether the contractor does it, or they do it, or they have to hire somebody who in then turn gets paid once it's done and it meets the town's approval. But there's three people that have to be happy here.
Well, I'm not sure everybody has to be happy. But what I'm saying here is that, and I'm not advocating either way. That's not my role to advocate here for a particular outcome.
And I understand that.
What I'm saying is that at some point, this commission needs to act. And if the commission never acts, I assure you the developer will never do anything. He doesn't have to. So my opinion is that you kick the 30 days in and at a minimum see what happens. And if there is no movement, then this commission can make the choice of consulting with the association and saying, are you willing to enter a hold harmless agreement with the town or aren't you? And I think that's the process. Commissioner Woods, this document is extremely vague, very vague. And sometimes that's good, sometimes it's bad. In the instance here, I think it is better for the parties that are in the room right now that it's vague, rather than the developer. He gets 30 days to come in and actually do something. And the document actually says he gets 30 days notice that the town is going to take over. So there's ambiguity right there. But something has to move forward.
Commissioner Fox and Commissioner Payne.
Okay, this has been going along, much too long, I think. It's been going since I was an alternate, and that was last spring or late spring, early winter, when we first heard about it. And I don't know if the rest of the commission would agree with me, but we were really at a loss of what to do. Because we really felt for the residents, and I have to agree with Commissioner Woods, the contract has some rights, but at the same time, I think he, I forget what word, he kind of canceled out those rights by not appearing before us. And I don't really, like you said, this is kind of vague. I don't know if we can trust him to do it. But I have a question for you, Counsel.
Yes, Commissioner.
We have to give him 30 days.
Yes.
Now, once he gets the notice, registered mail or what, and he knows that we are going to call the bond within, after 30 days, can he still come in and do the work?
Yes.
Okay. So.
It would behoove him to do so.
Yeah, I don't know. I like Commissioner Woods, and like I said last meeting, I would like to get that in writing, Ben, or as close as you can get to it. I know it's, it's kind of tough. You're coming in at this late. I'm inclined, though, to call the bond and wish our friends over there a lot of good luck and do what we can. Thank you.
Mr. Payne.
After the 30 days, what other rights does he have?
There are none.
None?
Technically, this would be an administrative issue. He could appeal it.
Oh, well, that's what I meant. So he
Because
does have the...
anything that's done administratively is appealable.
Okay, no, that's what I wanted to find out. If this commission called the bond immediately, is it correct that we wouldn't be able to act on it until our April 25th meeting?
Whatever the calendar is.
Okay, and the contractor is stating he's coming here on the 4/11. Okay, thank you.
Commissioner Sobieski.
One quick question. If the batch plant's open April 15th or April 20th, okay, and we run past his 30 days, and he says he can't get the material to do the binder course and stuff like that, what would your recommendation be?
I always recommend giving that extra ounce of latitude so that you've given every possible chance to somebody. And I'm not saying to go into June or July, that's not what I'm saying, but if the plants are opening, it's flexible. I don't know, when do they open? Sometimes it's...
They usually open around, depending upon the weather, around April 15th.
15th. If it's open and he's got a shot at doing it, I think he should do it. And if he shows up and he's actively working there, I would let him finish it.
Commissioner Payne.
Yeah, I just want to point out to my fellow commissioner, and I think Commissioner Woods would agree that at the present time, I wouldn't advise putting a binder course down there right now because there's a lot of heavy construction work that has to be done. There's probably over 1,000 yards of dirt that has to be moved from lot 1 and lot 2. He's going to have to cross the road, and there's other work that has to be done. There's cement trucks that have to go in there to do the foundation. So in his letter, he explains he wants to do that work and then put the binder course down in the middle of the summer, and that is the best time. Whether or not he completes everything that he's promising is a whole nother story, but I would not advise doing the binder course prematurely.
I completely agree with
Goes without
Commissioner
saying,
Payne.
yeah. Go ahead.
Commissioner Woods.
Couple more questions, Attorney
Commissioner
Ancona.
Fox, if you have other questions.
Does this commission have the power to pull the bond, or do we make a recommendation to the town manager? Who is the administrator of it? You-
Well, that's a very good question. I believe that this commission makes the recommendation to the town manager because the town manager is the acting party, is the contracting party. I mean, we call it a bond agreement, but in fact, it's a contract.
Correct.
I mean, we just don't put that term up there. It's a contract. And the contracting party is the Municipal Corporation of Newington. But the town manager is going to follow your guidance. That's why we do things like
And I understand
824 and
that
so
You
forth.
need to make the recommendation to get the ball rolling. I, as a newly commissioner, I don't have a problem with getting him on notice, that this commission plans on doing that. What I would say that he needs to be in here I think he said he'd be here at the April meeting, first meeting in April, with a plan, a detailed plan. And then from that, I believe this commission should act on it. If it doesn't happen, then I think we need to start doing it. But again, you gave him an opportunity to do this in the spring. None of the work could be done, and I understand it's frustrating for the individual homeowners that are there that have seen nothing getting done. But even if you were making progress talking with them, nothing would have happened until this point. And I don't know that he's going to do it or not do it. But again, I think it's the more work you could get out of him, the far better off you're going to be before this happens. And I think Attorney Ancona will probably agree with me. The more we get from him, the further that money will go, if in fact there is something that has to be done. I'll leave it at this. I know that Commissioner Sobieski was worried about when the plants are open. You don't want to replace that binder, even if you're doing it yourself. You don't want to do it April or May or June. No. You want to make sure that that ground is good and dry before you pull that old base out, put in the new base, get it graded, get it compacted. Then you'll have a road that's going to last you for 25 or 30 years. If you did that this April, that binder is going to be shot by this coming fall. So.
No, I completely agree with you. I just said that's when they open. But I would, obviously both you and Commissioner Payne, I wouldn't touch the thing till maybe June, till that dries out good, and then we'll remove the old binder course, put new base in, and then put the binder course back down.
There's a lot more that he has to do before it gets to the point where he puts a binder course down. He has to remove all of the dirt. He has to make arrangements as to what's going to happen with the foundations on the other lots. I mean, there's a whole bunch of other stuff. There's grading that has to be done at the catch basins down at the end of the street. When they do rip up the road, there's the sidewalk situation has to come in for site plan modifications. There's a whole bunch of stuff that has to happen before he starts putting down binder courses.
And I believe that's what I was addressing earlier, Mr. Chairman, Commissioner Sobieski and Commissioner Payne and the rest of you that have more knowledge than I do. These are the other elements that a 30-day notice could initiate and start getting some of that compliance. To say that you're just going to start getting there in July and working on the binder course and then deal with everything later on, I don't think that's a smart move. I think you got to put some teeth into this thing and at least get the process moving. And again, no disrespect, but the developer is in a better position than the association, as much as you may not like that, to get this process moving and completed.
Mr. Fox?
Frustrating. But one thing I have to say, suffice it to say that unfortunately the residents at Newington Ridge are going to be waiting at least another 45 days before they get any satisfaction one way or the other. For one thing, we don't know if this gentleman's going to show up April 11th. And if he does show up and comes up with a good plan that we all agree to, or maybe have some advice, from a professional or whatever. We don't know really no matter what kind of deadlines he sets, if he's going to take care of it within a parameter that we give him. Who knows? There's weather. There's other jobs. I'm sure this is not the only job he's doing. Seems like the guy that just kind of takes all sorts of jobs and then can't finish them. So it's. I'm just trying to tell the residents, or the 4 residents that are here, that unfortunately, I think you're going to need another month and a half, 2 months of patience before we actually see something happening one way or the other.
Commissioner
Thank you.
Camillo.
I think we should notify him for 30 days and see what happens on the 11th if he shows up. If not, you've already started the 30 days. We can take it from there.
Okay,
I
I
think
would
that's-
suggest also from the perspective of the residents in the Newington Ridge, that you go back to your association, you get some understanding whether you would approve taking over the bond, because that's, I believe, where the town's position is going to be, is that would be the only way that we would really like this to pull the bond, is under the conditions that you take it with a hold harmless agreement. But we need you to say, yes, we'll accept it under those terms, and have your attorney work with our attorney and the town planner and come up with an agreement that both of us could live with and agree to. But you'd have to agree to taking over and I don't know if everybody in your association would agree to that, or if that's your plan, or I'm not privy to any of that, so that's something that.
I'm happy to tell you when it's my turn to talk.
Okay. Why don't you let her come up
Please.
and talk, because that's an important issue, that's an important point that we have to get clarification on.
My name is Janet Chernikoff. I live on 4 Deming Farm Drive, and I am the Vice President of the Newington Ridge Preserve Condo Association. Commissioner Fox, in all due respect, Michael Massimino, who is the developer, could have done something. Maybe not physically with our property, but he stood before you in November. He promised you he would come before you after he spoke to us with a revised plan for acceptance and everything that we had suggested, such as no sidewalks, no gazebo, etc. He could have, in December, when you requested that he come, in January, when he did not show at either month, after numerous emails of which he did not respond, until today, when Mr. Minor yesterday, sent him a letter saying you were going to pull the bond. And now I don't understand, because to me, he's shown you, as commissioners and this committee, a lack of disrespect, why he is not required to come before you at the next meeting. There's no snowstorm. Why does you now given him another month? So why is he not required? Okay, you had a snowstorm, you had work to do, it's your prerogative to forgive him. Why does he have another month? Why not at the next meeting? We don't expect him to put down a binder course prior to the summer. We've listened to you, we agree with you. We want the dirt removed behind the lots 1 and 2. He said in his letter that he has a place, and I'm just going to read you something, an email that he sent me on May 1st, 2017, when we questioned him with the same thing. This concerned his lack for community landscaping, common elements, and development completion. He wrote to me, "We are committed to finishing the project this year. That said, our lender required us to sell Lot 1 and Lot 15 before we could proceed with the remainder of the lots. We will be mobilizing in the next 30 days, sound familiar, to start installing the remainder of the foundations. Once this is started and close to completion, we will begin to finish the remainder of the common elements, such as irrigation, sidewalks. We are in the midst of finding a location to remove the dirt pile, and we'll have an update within 2 weeks." There was never an update. As far as him putting in the foundations, which is what he's wanted to do, this is my questions. It was always my understanding that he could not put in the foundations until the environmental report was received and accepted. So I am asking the commission or asking the town planner, and Michael, sorry, Mike, has that happened?
No, my understanding is no. They have not submitted their report.
Okay, so this report now that he was supposed to do well over a year ago was holding him up, unless that's changed. He was not allowed to put in foundations until this environmental report was accepted, correct? Does that still hold true?
Correct. Yes, that's still a requirement of his wetlands permit.
Okay.
You need one.
The approval letter uses the term completed, so the way that it had been interpreted moving through the project is that the houses would not be CO'd. So he could build the house, but we would not issue a CO and certificate of zoning compliance until he had that taken care of. He's got to be he can go to 75% completion before he has to submit the wetlands report, but the term used in the approval is completed. So he could build all those houses and they can sit, and we would not issue that certificate until we had this.
I was told that he could not he could not dig the foundations, that because he was well overdue in his compliance with the report, that the town was holding back any additional permits to grant him, and that starts with the foundation. So clarify that for me.
Right, this is out of our territory, it's a Wetlands Commission requirement, so Mike and I are trying to give you our best understanding of what it is, and Mike has a pretty good understanding of it, but Mike is giving you his understanding of what the Wetlands Commission is going to require. That's a different body, obviously.
Okay, so as far as the town planner is concerned, would you issue him a permit for the next 6 lots that he has to build a foundation at this point in time?
Right, all right, I'll start to answer that, and then Mike will jump in. By state law in Connecticut, a building permit has to be signed off by the zoning enforcement officer. There's no similar requirement for wetlands. However, the zoning enforcement officer has a sort of a professional courtesy understanding with the wetlands agency. Mike will not sign off on a building permit if Mike knows, from what he's been told by the wetlands staff, that it's in violation of their wetlands permit. Is that correct, Mike?
Yeah, so I really am not in a position to be able to withhold the issuance of a building permit. The one thing that I would, personally, the one thing that I would add is I did speak with Eric Hinckley today. The Wetlands Commission will be discussing this at their next meeting, I do believe, because of the same issues with the wetlands report. And they may choose to take action, which would then change what can and cannot happen on that site. So I'd really defer to Eric, but I would not withhold issuing a building permit because we've already discussed with him the understanding that we would withhold the COs. And we've already had that agreement with him when we went and had issues with the wall and other things. We were withholding COs and certificates of zoning compliance.
Okay, so I understand you, and I don't want to be redundant. You would allow him to dig the next 6 foundations?
Per zoning, yes. We don't issue foundation permits. They don't piecemeal them. It comes in all together, typically. So I wouldn't approve a foundation permit and then come back for this or for that. It's a single family home permit is what we typically see.
Okay.
So I would not hold him back from that, especially now if he was going to do it, we'd urge him to move forward.
Okay. So now I have several questions that the community would like answered. Should mass construction, so he said he's going to come in April, he's going to do the work in May. Should he still not have a valid contractor's license when he performs this work, and the town still allows him to proceed? It is our understanding that the town of Newington is then responsible for any problems that arise. Is that correct?
I refer back to our attorney for an answer to that. I don't know.
I'll share this with you.
Well, without a valid contractor's license, he is technically not permitted to do the work.
Okay.
And you have knowledge that he still hasn't had?
As of today, he did not. I checked before I come.
Okay, thank you.
Okay. So the one thing that we also have a question with, I understand that the town doesn't want to get involved. I understand in May of 2015, the town entered into a contract with our developer, Mass Construction, and Michael Massimino signed off on it. If indeed, and they knew at this point in time we were a private community, that has not changed. So if at time, why would the town, if the town didn't want to deal with the bond, why would they take money for the bond and hold the bond for 2 years?
For your protection.
But aren't they then responsible because it was their contract?
We'll refer back to the attorney. Got an answer for that?
I don't have the original intent of the bond. Mr. Minor, do you have the recollection of what the intent was to enter that bond?
Oh, let me think about this. This was back in 2015. I think at that time, the staff was very concerned that there were aspects of the site that the developer, or the previous developer, had not done correctly. And frankly, the staff and the commission was concerned that the project might go belly up and leave the homeowners really with no recourse. So we then required the new developer, Mass Construction, to post a bond in the amount of the remaining work to make sure that, to protect the homeowners, to protect their interests in the long run.
Mr. Payne?
Yeah, matter of fact, the original binder was not put down by this contractor. It was put down by a previous contractor, which had all kinds of failures on the site.
Right.
Go ahead.
Okay. So I want to know, if our community was public and not private, and the developer left the project, would the town then assume responsibility?
We'd have to, yes.
Okay. Is it true that as a private community with an absent developer, that the association can call the bond at any time?
Mr. Attorney Iancona?
Well, you are the third-party beneficiary of the bond. However, the bond is with the municipal corporation, the town.
So the town, okay,
The town would have to do it.
okay. All right, prior to us
But I don't
accepting,
think there's a question of dispute between the town and the association as to whether, you know, we would pull it. We're telling you we would pull a bond. And
Okay.
with the money, we would give it to you with a hold harmless agreement.
so the money would come up front, so we would have money to
Yes.
spend.
Yes. Then you'd be responsible for completion of the site plan.
Okay.
But you'd also have the opportunity for modifications to that site plan.
So we would no longer require that the developer needs to be here for any site modifications?
No.
Okay,
You would have to come to the commission and ask for site modifications.
We know the
You would
way.
have to go to the engineer and have the plans revised to
Mhm.
show the conditions of the site that you want to modify.
okay, so prior to us giving you an answer, we would require in writing all items that remain on the bond, some items have been done, with an estimated cost per attached item and today's rate. This bond was set in 2015 at those rates. We are not experienced. I don't know, it's now 2 years later, 3 years later. Prices have changed. I'd like to know what we should expect to pay. So if we are bidding and a contractor bids much higher than we deem necessary, then we would have at least a reference. Do you think that's fair?
First Commissioner Woods, and then I'll go to the town planner. Go ahead.
My opinion, I believe this is when you need to hire an attorney. You need to go out and get estimates and secure those, work with your attorney, at the point then either with the town planner, or the zoning enforcement officer, somebody in here. But I don't think that's something that they're gonna be able to give to you.
Well, we have a bond right now, at least that's the copy I have. It lists per item. I don't know on that bond what's actually done and what's not. And is the builder entitled to any of that money on the items that he completed?
Well, yeah, I can speak to that. Actually, yes, in a better world, not even a perfect world, in a better world, he would have come before the commission many months ago and asked for a partial release, because he has, in fact, done a fair amount of that $190,000 worth of work. The staff told him, don't bother, because there's no way the commission is going to release any of that money until we have a much better sense that you are going to finish the project. There is...
Let's hypothetically, if you have 190,000, you spent 130,000 or 60,000, that money has to go back to him.
So he does get money?
Yeah, if you don't spend all the money,
But let's
am I
say-
correct, Attorney Iancona?
Right, that's simple mitigation. You would have to mitigate damages back to him. So if you were able to achieve the result at 160, like the chairman says, and there's 30 remaining, the 30 goes back to the
And if
developer.
there's nothing remaining?
He gets nothing.
Right.
Oh, okay.
And remember, if it costs more than 195,000 because of blueprints, drawings, engineers, and anything else that has to be modified, it becomes your cost.
We understand that.
Okay.
Okay. So, let's see. Prior to also accepting this, I would want a meeting, or the board would want a meeting with the appropriate town personnel to review all site plans. I have a couple of site plans, but I've been to your office. Seems to be pulling out more. I have no idea. Are we only looking, so when you say complete this project, we need a definition of what you mean by complete this project? Are we then supposed to be building homes?
No.
Only what's on the bond?
Just only what the bond is set up for. The bond says the bond is for the road, it's for landscape,
Okay.
it's for certain items. Those are the items that have to be completed under the bond. You have to meet that site plan, you have to meet the site plan that is approved.
Gotcha.
If you want to modify, take the sidewalks out, come and ask us for a modification. Probably we'll give it to you. The gazebo, you don't want to do the gazebo, come and ask for a modification. But all of those things have to be presented to us in a plan form so that we have a document, a site plan that is up to
Understandable.
date for what you are asking for. So there's engineering involved in that process.
Okay, so should we take over this project, as you're suggesting, what is the role of the developer? He still owns 6 lots.
His role is his role is, if he chooses to go in and build, he can build on those lots, sell those lots. Am I correct, Attorney Combs?
Absolutely. He'd be just like you would be.
Okay.
So he has rights there as owning 6, he has voting rights apparently in that association of one.
No, he's
6
not a member of our association.
Okay, well, what, doesn't he own lots there?
He has common interest rights.
Common interest rights. Sorry.
I think there's probably a problem that has to be worked out legally, and that legally is at what our association is responsible for and what he is responsible for. He has not turned over the roads to us. He has not turned over the hills, the land, the property. The only thing that the association, and that's a legal standing, which will come up, the only thing that the association is responsible for are our 10 homes, and mowing, and lighting, and snow removal of common property. But it's not the road yet, it's not, so I don't know how that works.
I think that's why one of the first meetings, the chairman recommended you have your counsel come in. You're going to need an attorney.
Oh, we understand that. We did not want our counsel to come in on the chance that the builder came in and you folks just turned everything over. We were not going to have him sit here hours on.
Oh, I understand that.
Yeah.
But
So
I
we
think
want.
at one point, there's so many unanswered questions that you will need to have a meeting with staff and the town attorney, along with your attorney.
Correct.
To resolve some of these issues.
All prior to us whether we accept this or not.
Right, so
Okay.
it sounds like to me that you have a lot of work to do between now and the time that you give us an answer whether you'll accept this bond, accept the bond money with the hold harmless agreement. So we have to know that to know how to proceed. I would love to, I'll ask the commissioners to give me what they would, their opinion as to what we should do, but it sounds like to me we might be a little premature to say pull a bond tonight. I mean, because you have all this other work to do. If you want to start the process, that's up to the commissioners. I don't know, Ben, what do you think?
Sure.
I mean, we
Two
have to
things
satisfy
first.
the town, too.
Right,
The
two
town-
things first.
He's the representative of the town.
The association, you filed, you were established with the secretary, everything's set with the state. So that in fact, you do have possession of common areas, because it's the association that controls common areas. Okay, so that's number one. Number two, I've got to put this on the record that this developer is in breach of this agreement. As we sit here today, he's in breach of contract, and I need to establish at this moment that nothing that this commission does or does not do may constitute a waiver. So I don't want anybody coming in saying you waived your right to pursue provision 4 of the contract. So my recommendation at this point is kick out the 30-day notice.
Okay, so I'm going to go to the commissioners and ask you whether you want to pull a bond tonight and kick in the 30-day notice. Commissioner Sobieski.
30-day notice.
Commissioner Payne. Yes. Commissioner Mike. Steve.
No, not, I haven't read the contract, so I'm not going to do it blindly.
Commissioner Fox.
Yes.
Hello.
Yeah. And Commissioner Claffey. Sorry, I forgot about you because I didn't see you.
That's okay, yes.
Okay, you have your answer. We will, I don't know what.
Okay, well, that was people expressed their opinion. Could I ask that be in the form of a motion?
Okay, can Stanley, can you make an?
Make a motion at the commission, and it starts the 30-day time clock.
Second.
Motion made, second. Any comments? Commissioner Woods?
I understand there's a 30-day time clock, and can you help me here? What are we doing with the bond? Because I don't know.
Well,
It hasn't been even determined yet. We're moving forward with taking something. We don't know if they're going to accept it, so that means we accept it, and I'm pretty sure this body just said, we don't want it. And stop me and...
Okay.
Sorry, Commissioner, you already own it. The town already has the bond.
Correct, but we don't want to step in and do the work.
Correct, but that's a different determination. That can be made at a later time. Right now is giving this, the town of Newington, you are recommending to the town manager, call the bond, and you can determine whether or not you want to step in and do the project, or come to an agreement with the association and have them do it.
Well, Attorney Ancona, can I rephrase that?
Sure.
What I heard the commission do tonight was to tell me to notify the developer that it is your intent 30 days from now to vote to call the bond. You didn't do it tonight. You just directed me to warn him that it is your intent to do this in 30 days. But you don't have to do that when that time comes. You can change your mind. But you need to let him know now that you might do that in 30 days.
My understanding is that you were going to give the 30-day notice pursuant to provision 4 of the bond agreement. And that is, your time is up.
Yeah, but you're telling me then he doesn't have the right to come in here and...
He does. He does.
Okay, and
Okay,
we...
you're going to afford that right because the town doesn't want to do it.
Okay, so he has a right to come in and give us a plan, and we could make conditions on that plan and put timelines on it and see if he complies with it?
Absolutely. That would be considered a modification of agreement.
What? Bob?
Well, I just, I think the Newington Preservers, they haven't even decided whether or not they would even accept the hold harmless and everything. Are we being premature with this? And should we put him on notice that if he doesn't show up on the 11th to explain himself, that then we're going to give the 30 days notice?
Now you're giving him 60-day notice.
Mr. Chairman?
Yeah.
Mr. Chairman? With all due respect, Dominic, he's had enough chances. I still think we should vote yes to call the bond 30 days. If he comes in the 11th and has a set plan, we think about that then. Although I don't even know if I would trust him then. I'm sorry.
Remember, he's in breach as we speak. We're almost at the year mark.
Well, it sounds like to me that the town's position through the town attorney is that we give him the 30-day notice. I mean, he's the representative of basically the town. I'm sure he's had conversations with the town manager, who was the ultimate one to make the determination. I mean, we asked for an opinion, we asked for his advice. He's given us his advice. He's telling us they're already in breach. Give him his 30 days. And then be incumbent upon the association to get working on whether they'll accept the bond or not. Because if we got to pull it, then we're going to be looking for a place to put the money. And the town is not in a position to be the developer on this.
In fairness, we were just notified of this yesterday. I
Okay.
think it's premature for us to make any decision until we have the facts. Craig, I would obviously like to schedule a meeting with you, Mike, whoever else I have to, you know, as a board, we will do that, just to give us an idea. We will discuss this, what our options are with our attorney, and we need to vote as a community.
Yep. Well, we could give them the notice. At the end of the 30 days, we pull the bond, the town can hold the money. If we choose, we will not act as the developer, so you have time, but I wouldn't spread it out too long, because we'll just hold the money.
And Janet, as I told you the other day, I'd be happy to come to your homeowners association meeting and answer their questions.
Yeah, see, I have too many, I mean, I know a fair amount of this, I certainly don't know all of it. I have no idea what's expected of us, and that's
why you need an attorney and a construction manager. You gotta.
Well, I need an attorney for our options,
Yeah.
et cetera, but I need to know, to present to the attorney, what exactly is required of us. None of us are developers, and yes, we can hire somebody, but I don't know what's involved or what he hasn't done with the environmental.
That's why you hire somebody.
Yes, but I need to know up front.
Ask those questions.
I need to know, we can ask those questions,
Okay. Oh,
okay? Thank you.
okay. Commissioner Koenig, got anything to add?
Yeah, I would just like to say it was tremendous foresight on the part of whoever decided that would staff this committee to actually ask for the bond originally, because we could be sitting here with nothing, and that would be a very different story.
So what do we need? We need a motion?
I think you just did, and I think Anthony was a no vote.
We're discussing it.
Okay, and we discussed it. All in favor?
Aye.
Opposed? One opposition. Anthony?
Well, I'm still a little confused at what, you guys went back and forth, so are we saying
Okay, what we're
yes to
doing is
the
we're giving them 30-day notice, and we're gonna pull a bond.
Gotcha. A yes vote.
Okay. Thank you very
Thank
much. You got some work to do, and recall,
Just for the
talk to
record.
the staff.
Mr. Chairman,
Yeah.
wasn't the motion to give him notice?
Not to pull it.
Right, give him notice
Right.
of the intent.
Yeah, exactly.
Okay, you're right, because the next meeting, then we would just pull it.
Well, no. If I send in the letter tomorrow, you can't actually call the bond until 30 days from tomorrow, which means your April 25th meeting. So,
Okay.
and he's coming before you
Yeah,
on the 11th.
We're
so-
all on the same page there. Okay.
You send a registered letter?
I'll send it the way the contract requires.
Okay, we're, the two items under new business, we've put those two items, A and B, we've taken them off the agenda. Petitions for scheduling, you want to read the first one? 0518.
05-18, special permit section 3.15.3, outside restaurant seating at 3260 Berlin Turnpike, Plaza Azteca. John Kennelly, applicant, Keybon Newington LLC, owner, Manuel Rubio, 3260 Berlin Turnpike, Newington, Connecticut, contact. The other 30,
You want to, any questions on this one?
Just going to schedule this for the next meeting, Mr. Chairman?
Yes.
Mr. Chairman?
Yes.
It looks like you have 4 things that you want to schedule for the next meeting. Is that correct? I got to wonder because our agenda is going to be pretty big.
Oh, no, just 2 new items for next week.
Okay.
Just this one and the bounce.
You got to do
Bounce around.
824 on the marijuana thing.
Exactly.
I mean, not an 820, a referral to Prague.
Referral, right. So those are April 25.
Okay.
and then
Thank you.
for this one, you get a letter from the fire, police.
Well, that'll be part of the presentation, yes.
Now, there's been some question from some of the commissioners whether we should even hear this. I think the planner has given you an explanation that we don't have, he has rights, just like everybody else, to come in with an application, even though he's got some negative things against him. And we still have to hear it and act impartially and act on it based on the information we get at the hearing.
Right.
Okay, go ahead.
So, okay, so March 28th for the Cinco de Mayo event?
Yes.
Yep, okay.
Petition 06-18, special permit, section 3.15.6. Place of physical activity at 2631 Berlin Turnpike. Joanna Soretta and Alexis Pena, applicants, 2631 Berlin Turnpike Associates LLC, owner Joanna Soretta, 304 Orchard Ave, Newington, Connecticut, contact.
All right, this is calling it Bounce House. It's one of those venues where folks can come in and have a birthday party for their kids. We have a few others in Newington.
Do they do food there too?
Well, let's see, in their application, yes, designed to accommodate parties and special events, as well as a concession area that serves a variety of tasty foods and popular beverages.
Okay, so will you look at the site as far as parking?
Yes, and we'll make sure that they have the same amount of parking, the same formula as we use for other bounce house type of venues.
It's a big size operation.
Yeah.
Okay.
And
we're putting those
I'm sorry.
on,
Yep.
and then the two that you brought in originally, the two applications you're going to send to CROG for a referral.
The first one, the text amendment needs to go to CROG, and so the earliest you can hold that hearing is April 25th. I would suggest you go ahead and schedule it now so that it's
You want to schedule
on the record
them now?
for the
Both
20
of them
for
at
April
the same
25th.
day, right?
What?
We're going to run them concurrently?
Yes.
Okay. So we'll put them on for the 25th?
Yes.
Okay.
Thank you.
Next item is town planner's report.
Okay, I recall I really didn't have anything to report other than I did convey to the town council the commission's request that the council oppose the governor's bill number 5045 regarding zoning regulations and fair housing, which I did convey it to them.
I've been brought to my attention that they're having a hearing at the Capitol tomorrow.
Right.
On Friday, is it? Okay, well, only way I knew about it, I read it on social media.
It was in the Current.
Huh?
It was in the Current.
Was it?
Earlier in the week, yeah.
Another bill that was talked about on social media also, 5488, according to a study on residential around COD.
Isn't that the same as the?
Yeah, but they're hearing them together, yeah.
Okay. You don't have, that's it on planner's report?
Yes, that's all I have.
Okay. Communications?
Yes, this is an article that was in the American Planning Association magazine this month, and it's an article on parking minimums, which I just thought was interesting, so I'm sharing it with the commission. Hartford just adopted new zoning regulations that basically eliminated minimum parking requirements. It's the latest thing. Sarah Bronin, who wrote this article, she's the chairman of the Hartford Planning and Zoning Commission. So I just put in there for your amusement.
Mm-hmm.
That's all I have.
So, that's a whole different situation, what they do in Hartford than what we could do out here in the suburbs.
Right.
Okay, anything else?
That's all, Mr. Chairman.
Commissioner Sobieski?
CROG?
CROG?
Yes, we had a CROG meeting last Thursday. Basically, we went around the table. Our dog issue was discussed a little bit. But the more important one is the 84 mess that's going to be created. They're planning by 2021 or 2022 to have the preliminary design in place. There's two proposals once they get past the, just before Broad Street. One is to bring it straight under, no tunnel now, this is just at grade. Second one is to put the railroad station to the west, underground, and then put the highway next to it, putting like a big circle around. Hartford is pushing to close the thing down and try to get it done in 3 years. that would be devastating to the surrounding towns, and I made my point to them. I said, I don't think that's a good idea. They claim that keeping the viaduct going is costing them $2 billion a year, or every time they repair it. That was about it.
We've discussed it a little bit before the meeting. You feel that if they close it down and all the traffic would come basically through Newington and some of the surrounding towns, then we would be basically really turning Cedar Street into the 291.
You turn it into a parking lot. What I think needs to happen is we need to stay on top of this. We need to have a lot of input into the DOT when they have the final hearings. And they need to do this probably in some type of stage construction where they allow the majority of traffic to go through. Otherwise, the surrounding towns, not only Newington, New Britain, Berlin, they'll all be inundated with traffic.
Any of the other towns' representatives saying what you're saying?
Yes.
So as a coalition, we could go in as a unified coalition?
They're waiting to get the final decision, but they see the same problem I do with the traffic.
How do you propose that we advocate this?
I'm going to wait until the final design is set in place.
Yeah.
Because then go it from there. Because I mean, they've got a couple of options. One is to build it in section or stage construction, as it's called, which would probably be better off for us. You know, but again, the idea is to put it at grade or actually below grade is what they're going to do, because the city wants to be made whole again, so to speak. So.
Mr. Chairman?
Yes.
I've been to a number of their planning meetings, and as I recall, there's a committee of the impacted towns that get together because they're all in the same boat.
Right.
And I believe they're represented by the respective mayors or city engineers or town managers, high level representation. So I think
Can we
Newington
find
should
out who
participate.
our representative is?
I will find out.
Would you please?
One other thing on that.
Okay.
If they go below grade, any tankers, hazmat, can't take that part of the highway. They'd have to come off and come through our towns and our cities.
Well, no, it'll be open. It's not going to be tunneled now. It's going to be open. It's going to be just like going through Hartford by High Street. We have the big walls going straight through.
Right.
And that's basically what's going to be. The tunneling out is out.
What will they do, connect the streets above it?
Sorry?
Will they connect the streets that it's...
Yes, there's going to be bridges and stuff connecting it, but the highway itself will be below grade to take the noise and bounce it back up and out.
One other thought, if you take Berlin Turnpike where it starts coming off 91, instead of going to the left, go to the right and go around Balf and drop on Hartford Avenue, you'd have a whole shortcut taking. A lot of the people that come down Berlin Turnpike come down Cedar Street and they go out to Route 9, and it's just an idea. I know it was a thought years ago. Stanley knows about it.
Yeah, I think if, I'm trying to remember, I can't remember, I thought half of that project, they abandoned the road, half went to the town, the other half
It's a
went
state
to
highway.
Balf, I
It's a
think.
state highway and it goes around, I believe.
No, that wasn't a state, that was a town road.
That was Jordan Lane.
Jordan Lane, I think is what it was called.
Right.
Yeah.
It was Jordan Lane.
Right, but the road itself,
It's gone.
Russell Road.
It's gone.
But the quarry,
Right, it's.
Balf took land that they didn't own, and there was a settlement.
Right, but it's
Part
just
of the
an
whole-
idea, it still can be,
Part of the quarry, right?
well, no, they're supposed to put a wall up and they haven't done that yet. Because the road still exists there, but it's, yeah, they took the whole bank out. But it's an idea, it's one way to alleviate the pressure of the center of Newington. No one's gonna wanna come to the center of town when this happens. It's tough enough now at 6 o'clock to say, hey, are we gonna go in the center and have dinner, or are we gonna stay home and wait till 7 o'clock till it clears? It'll be all day long. It won't even be just during rush hour, it'll be all day long. So something like that needs to be in place before this happens.
Okay. Anything else, Dan?
No, that's it, thank you.
Okay. Anything else from the commissioners? No. Public participation, anyone from the public wishing to speak at this time? Okay, remarks by commissioners? Any remarks, final remarks? Yes.
Just really a comment and a request to the planner. If we could be kept abreast of the Newington Ridge Preserve, or any correspondence that goes on, so we kind of have a handle what's going on for the next meeting.
Yeah. Copy all the commissioners on any correspondence. Any other commissioner remarks? Anthony, you still on?
Yes, I am, yep.
Okay, we're ending the meeting. You could go do whatever you're doing.
He's in Vegas.
Thank you, appreciate it.
I have no remarks. We had a motion to adjourn.
Make a motion to adjourn.
All in favor?
Aye.
Opposed? Thank you.
Aye.
Okay, thanks, Anthony.
Thank you, guys, appreciate it, bye.